All right. All right. Welcome back. Welcome back. And hello. And rodent last name. We've been through this before. I'm in Utah. I grew up Mormon. It's been a very, very, very long time. But here in Utah, Mormon Standard Time is a thing. And 5 minutes late is early, according to Mormon Standard Time. So I'm actually early. I'm actually early, but you're forgiven. So and hello, welcome, and Mrs. Bees and Emoji. I always struggle with your name, sorry, but welcome back. And Shelly, good to see you. So I say welcome back, but it's a momentous day. Hello, Cicero, Serial. It's a momentous day because this is the very first time I am hopefully streaming on Twitch alongside my YouTube stream. I've delayed it long enough. I've been thinking about doing it, but I figure why not, you know, grow the audience, have whatever audience I can. So I my analytics say one viewer on Twitch, but I have a feeling that's myself because I have it open in a different window to monitor, make sure I'm live and all that. iMuji. Okay. I'll try to remember that. But yeah, so if anyone is on Twitch, say hello. If you are watching on Twitch, please, keep watching on Twitch. It's terms of service. I can't tell you not to, but please open a second window, go like and subscribe on YouTube, and then do whatever you want. Keep watching on Twitch. That would be grand. If you're watching on YouTube and you happen to have Twitch, go, do the Twitch stuff, help me get into the algorithm, because yeah. Pat's Cats, good to see you. And so I mentioned I have it open in another window. Let me check. It looks like I am going over there. So that's good to know. I still think I am the viewer, even though I'm watching it in the stream manager, not other stuff. So that's the window I'm looking for. I do. iMuji. It's Peg Leg Finance, same thing. I figure make it easy to find. It's even the same crummy profile picture. So yeah. And since I am on Twitch now, I figure I better introduce myself. Hi, I'm Joe. I'm an attorney. I'm licensed to practice in the state of Utah. Today we are talking about a rather hilarious lawsuit in the state of Illinois. So, yeah, if you are not familiar with the lawsuit, since I haven't covered it on Twitch at all, I do have a past catalog on YouTube. Go watch it afterwards. It's all hilarious. So, yeah, and Calico Bell, good to see you. Brandon, good to see you. Yeah, I think I expect puns like that from you, but yeah, I think they are dead wrong. But Jermaine Down, thank you very much for the super chat. Yeah, this should be fun. This slap should be fun. It's I haven't read it yet, and when I say it, I mean them, because there's multiple motions, and so buckle up. It's going to be a long one, but it should be a fun one as well. I've only briefly glanced at one of them, and it looks good. I do have one or two stylistic complaints about it, but that's a me problem, not, as long as it complies with the court rules, that's fine. Judy, good to see you. So yeah, but that being said, since this is going to be a long one, I think I've waffled long enough. And Kevin Campbell, good to see you. It's hard to believe it's March already. But yeah, so we are in Braun versus Day. And last time we were here, we discussed the diversity issue, basically, that whether or not the court even has jurisdiction. And Janet came back and said, well, yeah, I really do live in Illinois, kind of. And so for now, the court said that's good enough for now. We'll see. And so let's see. We got an order on the 27th from the judge, basically saying that at least for pleading purposes, there is complete diversity. So what that means is, hey, at least for now, at least for motions to dismiss and SLAPP motions and, answers and whatever, the court is going to accept that there's complete diversity, meaning everyone lives in different states, or at least all the plaintiffs live in a different state from all of the defendants. Which the reality is there is complete diversity, period. The real question is this the proper venue? Because if no plaintiff is in Illinois and no defendant is actually in Illinois, can Illinois actually hear the case? So I think we're going to get a little bit of that in these motions. And then we also had, you may have seen this on Ian Runkle's channel, Runkle of the Bailey, because, he's faster than I am, but at least he's also better than I am. So the other day for Caffinated Kitti, they filed a motion for excess pages, basically saying, hey, judge, there's no way we're going to get this within the page limit. And either way, we're doing this to save you for judicial economy, because we could get it to fit within the page limits, but in order to do that, we'd have to do two motions, but then parts of that would be duplicative. And the wow, first Twitch stream, and I'm already getting crap. And how do I? Apparently I can't get rid of that in StreamYard, so I'm not even going to worry about it right now. But yeah. So basically they said it'll be duplicative for us to do two motions, because we'll have to do the history section and all that. And So why don't you just let us combine it into one extra large motion? The court said yes. So that's where number 18 in the docket was from a couple days ago. And as part of that, they attached as an exhibit the proposed special motion to strike and motion to dismiss. So this is in Illinois for now, Imuji. It's in Illinois, the Northern District of Illinois specifically. So it's Chicago. But yeah, so that was unopposed. It was granted. I didn't cover it because when it's the same thing we're doing today, because this exhibit here on docket number 18 is the actual motion in 21 and 22. So that's what we're going to do. But yeah, so I didn't think you'd be interested in the motion for excess pages. That's boring. That's procedural. We didn't need that. I'm just mentioning it. So what we do have, and this is, once again, all of the defendants have the same attorney. I'm sure they all waived conflict. They knowingly and voluntarily waived conflict. That's fine. But they all, each set of defendants have a separate motion. So we have 21 and 22 is Caffinated Kitti, 23 and 24 is Bekah Day, and 25 and 26 is Lily Marston and Jesse Vasquez. The Do We Know Them girlies. So even though, in order to save pages, they combined the motion to strike and the motion to dismiss for Caffinated Kitti, they could have saved more pages by combining all of these motions, but they didn't. And that's fine. That's, that just in reality gives extra work for Janet and her attorney, Mr. Lockyer, who, yeah, that should be fun. But yeah. So unfortunately, Illinois is another one of those jurisdictions. Like I said, I appreciate Nevada combining the motion and the memorandum in support into one docket entry, one document. Makes it easy, makes it cleaner. I prefer it. Illinois, do better. Massachusetts, do better. Just do better. But that being said, we're going to do them in order. So we're going to do Caffinated Kitti first. And Linz, it's good to see you. Thank you for being here. And so yeah, this is defendant KC, the owner and operator of the online social media account Caffinated Kitties, special motion to strike pursuant to OCGA section 9-11-11.1, or in the alternative, motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-6, 12b-3, and 12b-3. So I guess I should have pulled up the Federal Rules of Civil Procedure. I've done this before. It's almost like I need this website every live stream, so I should have come prepared, but oh well. So since this is the first time we're doing 12b-6 and 12b-3 on this lawsuit, I figure there's some overlapping audience for those those of you who are sick of hearing me talk about 12b-6, go ahead, cover your ears. We'll be done in a minute. But I figure there's also new audience who's come for this case. So even though we're duplicative, we're going to cover it as if we haven't before. So Rule 12 is, in general, defenses and objections when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, and pretrial hearing. So 12A, or generally, it's when do you need to respond? Generally 21 days after. So we don't need to do that. But 12B is how to present defenses. So this is basically the motion to dismiss. And Imuji, you are correct. And Teragi, I have watched Ian's because, I wanted to come into this fresh. Like I mentioned, I've only looked at a tiny bit of it, but I like it. And I noticed, in the line or two I looked at, there was a lot of shade. And what does Emily D. Baker say? Shades and allegations, at least the pleadings are. So, oh boy, is there going to be shade and allegations. And 12b-3 is improper venue. You are correct, Imuji. So basically 12b, how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party may assert the following defenses by motion. And so 12b-1 is a motion to dismiss for lack of subject matter jurisdiction. So if it came out that, let's say Janet did live in California, like for a little while we suspected she did, then there wouldn't have been complete diversity. So the federal court would not have had jurisdiction to hear the case, because in order to hear state law claims, which these are all state law claims, so presumably the state court would have the jurisdiction to hear it. Federal court can only hear it if there's a special jurisdiction giving them the right to hear it. And in this, it would be diversity jurisdiction. So if there were no diversity jurisdiction, we'd have a 12b-1 motion, a motion to dismiss for lack of subject matter jurisdiction. 12b-2, motion to dismiss for lack of personal jurisdiction. That means the court doesn't have power over you, the defendant. 12b-3 is improper motion to dismiss for improper venue. So venue is, where is the case being heard? And so we already saw just from the caption of Caffinated Kitti's motion that they are moving to dismiss for lack of, or for improper venue. And J. Ben, good to have you for the live. So basically they're saying, hey, the impact of this was not felt in Illinois because Janet is in South Carolina. Lauren is in either Florida or Wisconsin. Who knows? She claims Wisconsin, but you all tell me Florida. So, Caffinated Kitti, I live in Georgia, so I didn't do anything in Illinois. So the Illinois court doesn't have the right to hear this case because it's the wrong venue. It should have been brought in Georgia, Florida, South Carolina, or Wisconsin, presumably. So that's what the 12b-3 is for. 12b-4 is motion to dismiss for insufficient process. 12b-5, insufficient service of process. As far as we know, they were all served properly, so that doesn't matter, at least for our purposes. 12b-6 is the one you hear me talk about most often, and that's the motion to dismiss for failure to state a claim upon which relief can be granted. So that's the one you hear me talk so much about Twombly and Iqbal, two Supreme Court cases about the sufficiency of pleading. And it what is insufficient process? It's been so long since I've dealt with insufficient process. Like, I've never dealt with it actually in court. So it's thinking all the way back to civil procedure. It's basically you didn't follow the court rules. You didn't follow the rules for how to serve process. I can't remember the difference between insufficient process and insufficient service of process. But like I said, it's irrelevant for today. I've never had to deal with it, so it's not fresh in my mind. But yeah, so for 12b-6, you've heard me talk about Twombly and Iqbal so often in other cases. I think I even mentioned it going over the complaint because it's so bad. Because remember Rule 8, the general rules of pleading. That this is going to be in the motion to dismiss, don't worry. But 8A is the claim for relief. So a pleading that states a claim for relief must contain 3 things. 1, a short and plain statement of the grounds of the court's jurisdiction. So that's the jurisdictional statement. That's, in this case, diversity jurisdiction. 2, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for the relief sought is number 3. So for Twombly and Iqbal, we are, and the 12b-6, we're worried about 8A2, the short and plain statement of the claim showing that the pleader is entitled to relief, because we don't think that Janet and Lauren have stated a sufficient claim, because as Twombly and Iqbal will talk about, and we'll see it in the motion, I'm sure, is it can't be fanciful, it can't be delusional, as we've seen in Schofield versus Guillard. It can't be conclusory, and it can't be conclusions of law. It has to be actual facts or factual allegations. And for the purposes of the 12b-6, those factual allegations are taken as true, but only for the 12b-6. So there's one more thing we need. So 8D, pleading to be concise and direct, alternative statements and inconsistency. So we need 12b-2, alternative statements of a claim or defense. A party may set out 2 or more statements of a claim or defense alternatively or hypothetically, either in a single count or defense or in separate ones. If a party makes alternative statements, the pleading is sufficient if any one of them is sufficient. So, Linux guy, I shudder to think what havoc delete laws could do if he teamed up with Lauren. I mean, everything would be dismissed eventually, but they could, you know, at the very least, cost people attorney's fees for defense. So, yeah, we've talked about alternative statements, alternative pleading in past cases, but like I said, this is new for this case. So basically, I read the rule. What does it mean? it means you can say, well, Your Honor, we think this applies. You know, we think the sky is blue. But if the sky isn't blue, we think it might be pink. And, you know, we want you to take both of those in mind, and, you know, both can't be true at the same time. But we'd like you to consider both of those. And the court could say, well, yeah, the sky's blue and that other claim is dismissed, or, you know, whatever. But it also, for motions, because you'll notice this is the special motion to strike, that's the SLAPP motion, or alternatively, motion to dismiss pursuant to Federal Rule of Civil Procedure, Rules 12b-6 and 12b-3. So basically, what Caffinated Kitti is doing here is she's saying, Your Honor, we would like you to slap Janet and Lauren, and YouTube and Twitch, slap SLAPP, Strategic Litigation Against Public Participation. This is a SLAPP suit. So we'd like you to issue the special motion to strike and dismiss and grant us attorney's fees in the process. Basically, it's the short circuit. Get rid of the case right out the gate. But if you don't think this deserves to have the special motion to strike granted, in the alternative, we also think that they've failed to state a claim upon which relief can be granted, 12b-6, and they brought this in the wrong venue, so you've got to dismiss for that too. Now, 12b-3 would probably be dismissed without prejudice, and then they could bring it in South Carolina or Georgia or wherever. So, Brandon, that's a good question. I don't think there was ever an official uncivil procedure, but before they standardized the Federal Rules of Civil Procedure, it was a bit more of a free-for-all, is my understanding. Of course, the rules of civil procedure were enacted long before I became a lawyer. Of course, we've seen some litigants that do engage in what might be considered uncivil procedure. So, this is, like I said, this is the motion, real short, and then we get the memorandum as a separate document, which annoys me, but whatever. So, pursuant to OCGA Section 9-11-11.1, or in the alternative, Federal Rules of Civil Procedure 12b-6 and 12b-3, and for the reasons stated in the attached memorandum in support, Defendant Casey, the owner and operator of the online social media account Caffinated Kitti, respectfully requests that this court strike and or dismiss plaintiffs Lauren Propson, Jeanette Braun, and Braun IP Law, LLC's complaint against her. So that's short and sweet. And remember, Caffinated Kitti is not public with her actual name. So we're just getting her initials, KC. So Lauren and Janet are actually doing something decent for once. And, you know, they're doing the bare minimum, and they did dox her before their motion to seal and all that. But yeah. Benjamin Cano, I see your Guns N' Roses reference there. I think that might be my favorite song by Guns N' Roses, Civil War. So we have now the 35-page memorandum in support of Caffinated Kitti's motion. And of course, 35 pages, but that includes a couple of fluff pages. So Sarah J, enjoy your dinner. So we've got the table of contents. I always appreciate a good table of contents. So right there, the Girlies lawyer is already better than Benjamin Lockyer. Although I do have, like I said, a quibble or two stylistically from what I saw. But we have the table of authorities. So these are all, this is the case law. I mentioned, I guaranteed that we'd see Iqbal and Twombly and scroll through. Actually, let me scroll back up. No, Conley versus Gibson, the case that preceded Twombly, which it's not good case law anymore, but whatever. I only bring it up because Mr. Me in Delete Law's LVMPD case seems to think Conley versus Gibson is still the standard because he's not a great lawyer from what I've seen. But lots and lots of cases, and then we've got some statutes that we are dealing with. And then we've got some other, Fed practice and procedure on jurisdiction. So that's basically scholarly article, practice guides, whatever. So introduction. Now, this is what I don't like stylistically. You'll notice there's no line numbers on the left-hand margin, and he doesn't number the paragraphs. So that makes it hard to cite to this motion in the opposition to the motion. I don't like that. That's just me, but yeah. And Benjamin, it could be that Mr. Me, that's what he's doing. So yeah, introduction. Interrogee, this is lots of shade here in this first sentence. So at its core, this action is an attempt by an alleged well-known social media influencer with millions of followers and her lawyer to silence an individual who has voiced opinions about them on social media with which they disagree. While plaintiff Lauren Probson and her lawyer, Jeanette Braun, also known as Janet, that's what we'll call her, and Braun IP Law, collectively Braun, may not like what defendant KC, the owner and operator of the social media account Caffinated Kitti, hereinafter KC, has to say about them on TikTok. The allegations of the complaint reveal that KC's alleged statements are nothing more than her opinion, her subjective beliefs, and, at worst, hyperbolic name-calling. They are not actionable as defamation, as a matter of law. And that is in bold and italics. They are not actionable as defamation, as a matter of law. Not one of the alleged defamatory statements is a verifiable statement of fact. Not only do these statements not constitute defamation under the applicable substantive state law, but, importantly, they fall within the scope of protected activity under the Georgia anti-SLAPP statute, which governs Georgia speakers such as KC, who the complaint alleges is a resident of Georgia. Interrogee, that's I missed that, but that's a good point. That's a very good point. that Janet, I'm a federal civil attorney. And the Girlies lawyer's like, yeah, she's a lawyer. That's a good catch. That's why I keep you. That's why I have you here. Put simply, this case is nothing more than a joint and inappropriate attempt by a lawyer and her client to bully and intimidate an individual for speaking her mind and exercising her First Amendment rights. Indeed, the complaint itself reveals the lengths to which plaintiffs will go to harass Casey for voicing her opinions, namely, calling the local police in Georgia and sending them to conduct a wholly fabricated wellness check on Casey. And Tara, I hope she's seething. I hope she has all the salt this weekend. But so this line right here. So put simply, this case is nothing more than a joint and inappropriate attempt by a lawyer and her client to bully and intimidate an individual for speaking her mind and exercising her First Amendment rights. Where have we heard that basically confirmed? Well, that would be from CC Suarez in her video where Janet attempted to take down her video on YouTube talking about Bunny XO. And basically the video she tried to take down was where Bunny had Lauren on her podcast. And they talked about doing this exact same thing. And Bunny XO was like, well, yeah, if they're talking shit about me, I have my lawyer take that down. I don't care. So, admittedly, Bunny XO is not a party to this case, but she admits on video. My audio cut out. Hopefully that was just my headphones. But she admits on video that that's what her attorney does for her. And it's what her attorney does for Lauren as well, or at least that's what it appears to be. And the Girlies lawyer is calling her out for it. Because plaintiff's allegations of defamation are based on statements that are a protected activity under Georgia anti-SLAPP law and are legally deficient and non-actionable, the Georgia anti-SLAPP statute mandates that all 9 causes of action asserted by plaintiffs against KC, all of which arise out of the alleged defamatory statements, be stricken and attorney's fees awarded to KC. And you'll notice, for those of you who have been here for a while, that in Schofield versus Giard, the TikTok psychic Giard has complained endlessly. I'm in Texas. I don't know how you guys are hearing this case in Idaho, even though she didn't bring a 12B3 motion. She brought it as a counterclaim as improper prosecution of a case. It's like that's not a counter motion or a counterclaim. It's a motion to dismiss, and you didn't do it, and you've kept complaining about it even though you've waived it. But here you'll notice Caffinated Kitti is not waiving it. She is raising it in her first responsive pleading. So in Schofield versus Giard, because the actual damage was all felt in Idaho, because Professor Schofield is a professor in Moscow, Idaho. Her friends and family are all in Moscow, Idaho. She lives in Moscow, Idaho. Her reputation is Moscow, Idaho. But with Janet, she says, well, yeah, I'm a part-time resident of Illinois, and that's where my LLC is incorporated. But you know, she runs a nationwide practice. Her client in this case is either in Florida or Wisconsin. Bunny XO is in Texas. You know, all her clients live across the country. So if she's felt any actual damage, it's nationwide. So Georgia would actually be the appropriate place, at least as far as Caffinated Kitti is concerned, and therefore Georgia law applies. And so they're asserting that right here, right now. So, Judy, I assume it's the puppy in your profile pic. Give the puppy all the scratches and give him a treat from me, because yeah. So can Georgia's SLAPP laws apply? Maybe. We'll see. Once again, they're trying to say, hey, Georgia's anti-SLAPP law does apply because you brought it in the wrong venue. If you had brought it in the appropriate venue, it would apply. And you'll notice once we get to it, well, let's just, so that I don't forget. So with Bekah Day, because she's in Missouri, hers is simply a motion to dismiss for failure to state a claim. So Missouri doesn't have an anti-SLAPP law. So they didn't bring a SLAPP motion. Whereas in the Do We Know Them Girlies, there is the special motion to strike because Lily lives in California, one of the strongest anti-SLAPP provisions, and Jesse lives in Georgia. So both states have anti-SLAPP laws. So they're really trying to say, hey, you brought it in the wrong venue. And so we want our substantive law applied because it's better for them. Illinois does have an anti-SLAPP law. So Illinois does have an anti-SLAPP law. The problem with Illinois is it was initially quite a robust anti-SLAPP law, but then the Illinois Supreme Court basically gutted it, which was wrong of them to do because it goes against the intent of the law, the legislative intent, but it also goes against their previous case law on it. So that for quite a while, I don't know how long, but for years, they had ruled that it was a strong anti-SLAPP law. And then all of a sudden they said, yeah, no. And so if you got in early enough, it helped you. But now it pretty much is only if you're speaking about politics. A politician can't bring a SLAPP suit against you, is my understanding. Once again, I'm a Utah attorney, not an Illinois attorney, but that's my understanding. So back to it though. So alternatively, KC respectfully requests that this court dismiss all 9 causes of action asserted against her for failure to state a claim under Federal Rule of Civil Procedure 12b-6, given that, as explained below, all of her claims rely on alleged defamatory statements that simply are not actionable under applicable law. And I agree, Emoji, it is dumb of this Illinois Supreme Court to have done that. Alternatively, and at a minimum, Propson's claims against KC, which are curiously joined with Braun's claims, should be dismissed under Federal Rule of Civil Procedure 12b-3 for improper venue because Propson is a Wisconsin resident, Casey is a Georgia resident, and this venue has no nexus to, involvement with, or interest in the adjudication of Propson's claims. Brandon, you've made that joke before. You've made that before. But I still appreciate it. So that's a good point, though. Lauren the Mortician and Janet, their claims are completely different. They have no joint claims. None of them are based on the same allegedly tortious conduct. So the reality is this case, these claims didn't need to be brought as a joint lawsuit. And frankly, Caffinated Kitti's allegedly tortious conduct is completely different than any of the conduct brought by the other girlies. And as far as if I remember right, the other girlies, Lauren doesn't even have any claims against them. If I remember right, there might be one, but basically the claims against Caffinated Kitti are about calling Lauren a TERF and Janet an allegedly rogue attorney. Whereas the claims against the other girlies, if I remember right, are all about calling Janet an allegedly rogue attorney. So how are they curiously joined? It just doesn't work that way. It does not work that way. But the case background. Plaintiff Lauren Propson is a social media personality, and plaintiff Janet, through Plaintiff Braun IP Law, is her lawyer. So Janet is Lauren's lawyer. Propson is a licensed mortician residing in Wisconsin, maybe. And that's exactly it, Linz. That's why we have the 12b6. And if the special motion to strike, the SLAPP motion, isn't granted, then frankly, the 12b6 should, because these claims are terrible. But Propson is a licensed mortician allegedly residing in Wisconsin who operates a social media account on TikTok under the name Lauren the Mortician. Propson alleges that she has amassed millions of followers on TikTok, in quotation marks, as well as sponsorships and monetization of the videos she posts of TikTok, including a brand partnership with a famous documentary channel. She doesn't tell us what the famous documentary channel is, so that's not a very good allegation. So, Linux guy, I think Blue Bacon attempted an anti-SLAPP motion, but that was before he hired his attorney and he bungled it. So, yeah. And most of Delete Law's case hasn't made it past a 12b6 motion. I don't see it surviving past the currently pending 12b6 either. I could be wrong, and it could be the summary judgment motion that it's decided on, but yeah. Lynn's, no idea. All I know is what was put in the complaint. I have never watched Lauren the Mortician. It's bad. And Katie Gray, we appreciate bad jokes on this channel. So rolling in her grave, rolling in someone else's grave, you know, we don't kink shame if that's what she likes. So, and her saying, they bring their own allegations saying, well, yeah, she's amassed millions of followers. So under the plaintiff's own admission, under their own pleadings, she's a public figure. So the heightened pleading standards off of New York Times versus Sullivan apply. So there needs to be actual malice. That's a pretty high standard to meet. And when you can't even bring a claim that would survive a 12b6 on regular pleading standards, there's no way you're going to survive the actual malice standard. So, yeah, it's a bad look even bringing this case. But, yeah. Probson alleges that her light-hearted and educational videos posted on TikTok discuss death, the loss of loved ones, and demystify occupations and professions that work with deceased persons. But apparently that also includes giving your opinion on car seats. Maybe? Apparently. So, yeah. Probson hired Braun, a lawyer, to assist her with copyright infringement claims by filing a DMCA, Digital Millennium Copyright Act, complaint to social media platforms hosting a video created by one of the defendants, who the complaint names as KC, the owner and operator of the social media account Caffinated Kitti. The complaint alleges that KC is a social media personality and is a citizen and resident of Georgia. The complaint alleges that Braun, who resides and is licensed to practice law in Illinois, filed a DMCA complaint with the social media company Meta on behalf of Probson to remove from Facebook a post created by KC on the ground that KC's post used Probson's copyrighted material. And she does this in spite of the fact that she uses other people's copyrighted material on her TikTok. So she has unclean hands in even complaining about copyright issues. And Katie Gray, I have no idea why Jamie Grayson isn't involved in this case. It's maybe they realized how bad it would look to be suing him when, frankly, he was their victim. And from everything he's indicated, he's looking into suing them. So, yeah. Brandon, Brain will triumph over Braun. I mean, you're right, but yeah. The complaint alleges that Meta approved the DMCA removal request filed by Braun on behalf of Probson, and it removed Casey's post from Facebook on November 4th, 2023. Probson has not asserted any allegations of copyright infringement against Casey in connection with her alleged use of copyrighted material in her Facebook post. Rather, this action is based on allegations that Casey posted videos on another social media platform, TikTok, in which she made alleged defamatory statements about Probson and Braun. So basically, they're saying, why even bring up the alleged copyright violations on Facebook, which were probably fair use anyway, but why even bring them up when they're completely unrelated to any cause of action you actually brought? It doesn't make any sense. Unless all all you're doing by bringing it up is trying to show the court, look, we've got beef. You know, we're Wendy's. We brought the beef. Or, you know, why else would they even bring it up? Based on these alleged defamatory statements, Propson and Braun both assert claims for defamation, false light, and trade libel against KC. In addition, Propson asserts claims for tortious interference with contract and intentional infliction of emotional distress against KC. And Braun asserts a claim for tortious interference with business relationships against KC. Really? Really? Calico Bell. And is it Lauren or Janet that uses EDB's logo cup? Either way, if they're using someone else's logo as their logo, that could vary. You know, that's probably not fair use. That wouldn't be fair use. And even though Emily isn't covering this case, I loved it on the Friday night frenzy on Law and Lumber when Ian and Rob were regaling her of tales of this case, and she was rolling with laughter. It was hilarious. So, defendant KC's alleged defamatory statements regarding Propson. Propson alleges that on or around October 24th, 2023, KC published a video on TikTok and identified her by her public persona, Lauren the Mortician. And we've got the link here. We won't watch that because we're already going to struggle to get through what I want to get through. The complaint contends that in the 10/24/23 TikTok post, KC accused Propson of being transphobic and a TERF because she liked posts by a social media personality who is in a gay relationship. The complaint alleges that TERF is a derogatory slur, highly offensive term, and acronym standing for Trans Exclusionary Radical Feminist. And Teragi and the Linux guy, she is a bully. I absolutely believe that she's a bully. They're both bullies, I should say. So, and TERF, which is a term used to refer to or describe an advocate for radical feminism who does not believe that transgender people's identities are legitimate and who is hostile to the inclusion of trans women in the feminist movement. The complaint then sets forth screenshots from the 10/24/23 TikTok post in which plaintiffs allege that defendant KC accuses Ms. Propson of being a TERF and transphobic. One of the screenshots depicts a picture of KC with the text, Lauren the Mortician is a TERF. The other screenshot is a depiction. Like I said, in general, I like this attorney. I'm still going to call out his spelling errors. Is a screenshot depicting a picture of KC with the text, Lauren the Mortician is a TERF. The other screenshot is a depiction of a picture of KC with the text, unfriendly reminder, we see transphobic, so we're saying transphobic. That ain't bullying. It's an astute observation. Boondocks 2014. And bi people can be transphobic. Neither of the screenshots depict any text stating that Propson is transphobic. So this is important. Bi people can be transphobic. We see some people who are on the LGBT spectrum right at LGB, leaving out the T because, you know, they're like, hey, I need my rights, but, you know, those trans people, don't lump them in with me. And yeah. So presumably Janet has money. Who knows? I have a feeling Lauren might be the one that they're able to collect from more. But you know, that could just be, you know, me guessing based on the relative size of their social media and the fact that I don't think that Janet's a very good attorney. So I don't know. I mean, she might make money at it. I don't know. Prop alleged that in explaining her reasons for her accusations, defendant Casey stated that she was not accusing Ms. Propson of being transphobic because Ms. Propson has a larger fan base and following, but because people were confusing Ms. Propson's Lauren the Mortician persona with defendant Casey's Caffinated Kitti persona. And you'll notice here, once again, Lauren and Janet don't seem to get that Caffinated Kitti puts on a persona for the camera. It might not be too far from her actual real life persona, but you know, that they're pointing it out. Hey, Lauren the Mortician is a persona. Caffinated Kitti is a persona. I should maybe start charging an arm and a leg for stuff. I mean, you know, my legs are expensive, so maybe I'll give them half off of an arm and a leg, and just, you know, of course, the leg I want is like 120 grand, so that's still expensive. But yeah. The complaint further alleges that in the 10/24/23 TikTok post, Casey also announced that she compiled a list of links to posts that Ms. Probson liked that contained transphobic and hateful rhetoric. Careful, Brandon. I can also kick you long range. I mean, maybe not all the way to where you are, but you know, my leg isn't particularly aerodynamic, but it, you know, it only weighs like 8 pounds, so I can throw it across the room to kick you. So be careful with those. Yeah. So the complaint depicts another screenshot of the TikTok post that depicts a picture of Casey over the background of a social media account profile for an individual named Anthony Raimondi under the profile name Conservative Aunt account. The screenshot further depicts a comment from Casey stating that I'm not the one for drama, but when I'm getting confused for someone, it becomes my business. And I value being thorough when it comes to addressing any accusation against someone else. Is it too much to ask that people hate me for who I am? Anyway, take my information and do your own research if you'd like. But refusing to address why hateful content is so likable smells like me. I'll post my link in the comments for y'all, but do not comment on this guy's derogatory stuff. It is rage bait for a reason. So talking about conservative ants, rage bait. And yeah, Brittany Edwards, I like reading well-written motions, even if I do complain about the lack of paragraph numbering. The complaint alleges that upon information and belief, none of the videos defendant KC linked contain transphobic and hateful rhetoric. And upon information and belief, defendant KC's motive and intent behind these posts were to tarnish and damage Ms. Probson's reputation. Well, upon information and belief isn't a factual allegation. You're saying, yeah, we think this is why she did it. That's not a factual allegation. I don't think, upon information and belief, that's good enough for surviving a 12b6 motion. But it's also, you know, we don't think any of the videos contained transphobic and hateful rhetoric. But here's the thing. If it's Caffinated Kitti's opinion that conservative Ant's videos were transphobic and hateful, that's her opinion. That's her opinion. And opinion is protected. Opinion is not defamation. And I mean, it depends on the jurisdiction. It's, you know, every federal court has different rules for, you know, page limits, for style, for font size. That's why they say, you know, you've got to read the local rules. So, you know, you've heard me complain multiple times already today about the jurisdictions that split the motion and the memorandum in support of the motion into two separate files, two separate documents. And, you know, Nevada, as we've seen, doesn't do that. It's one file. I prefer that. Clearly, Illinois doesn't allow that. When to Castro versus Abrams, we saw Massachusetts doesn't allow that. So I've never practiced in Illinois. As I say, I'm a Utah-based attorney, and it's possible that Illinois doesn't, and it might even be they don't want it. I'd assume that this attorney is, from what we've seen, is a very good attorney. So hopefully he's following the rules to a T. So when viewed in its entirety, it is apparent that the statements made by KC in the October 24th TikTok post are limited to statements by KC that Propson actively follows and likes social media posts that contain transphobic and hateful rhetoric. And because KC finds such rhetoric offensive, she does not want people on social media to confuse her for Propson or her Lauren the Mortician persona. Nowhere in the TikTok post does KC state that Propson or Lauren the Mortician is transphobic or has made specific transphobic statements herself. Rather, only that she has liked posts by other individuals who have made transphobic statements. Nowhere in the complaint do plaintiffs allege that Propson has not liked these posts or followed these individuals on social media. Moreover, nowhere in the complaint do plaintiffs allege any facts demonstrating that any statements made by KC in the TikTok post are false. Defendant KC's alleged defamatory statements regarding Braun. As stated above, Propson hired Braun to file a DMCA copyright complaint with Meta regarding KC's alleged use of Propson's copyrighted material in a post on Facebook, not TikTok, which Meta approved. The complaint alleges that Casey then used her social media accounts to express her anger and resentment of Braun. Specifically, plaintiffs allege that on November 21st, 2023, Casey posted a video accusing Ms. Propson of using attorney Braun to file bad faith copyright claims with social media platforms, and in the same video, Casey accused Braun of filing bad faith copyright strikes against defendant Casey, which I agree. If they were fair use, whether Facebook approved it or not, and my understanding is Facebook pretty much rolls over if anyone files a copyright strike, legitimate or not, Facebook just doesn't want to deal with it, so they'll say, all right, bye-bye. Whereas YouTube will sometimes, they're not consistent, but sometimes they'll be like, yeah, so we think you're wrong, so we're not going to take it down. You can sue. Whereas Facebook doesn't do that. So Lauren and Janet tried to say, well, look, Facebook did what we told them to do, therefore we were right. But as Janet so astutely says to YouTube, you're not the judiciary. You are not qualified to decide. Well, in that case, what Facebook did or didn't do doesn't add any legitimacy, and it's Kitty's opinion that it was a bad faith copyright strike, which I agree with. And that's it, Taragi. It probably was just the automatic bot. You push the button saying, hey, this is copyright violation. This is my work. And no human eyes probably looked at it. And I mean, Facebook, their reporting system is garbage. I mean, rant from Joe time, but my personal Facebook feed sucks. It's 99% is not my friends. It's targeted ads and videos and crap, and most of it doesn't apply to me. Most of it is terrible, and you can't unfollow a page. You can snooze it for 30 days, but you can't unfollow it unless you report it for something. So I usually report it for spam, and and then say unfollow. But that doesn't seem to stop identical content from springing up in its place. Fix your platform, Facebook, although I realize you made it crappy because that's what makes you money, and money is nice to have. Plaintiffs allege that Casey posted the same video again on TikTok on November 25th, 2023. Both TikTok posts are collectively referred to as the 1123 TikTok posts. Contrary to the allegations in the complaint, nowhere in the 1123 TikTok posts does Casey state that Braun filed bad faith or false copyright claims or strikes against Casey. We have a transcription of the TikTok posts, but we're not going to look at those right now. To the contrary, Casey does not even discuss the copyright strike for most of the video. Rather, Casey describes how Braun called the police and sent them to Casey's home in Georgia to conduct a wellness check, as well as how Braun sent Casey a cease and desist letter on which Braun copied Casey's mother and a theater company with which Casey is not even affiliated. Plaintiffs further allege that on November 21st, Casey created a page on the donation platform called GoFundMe and posted on this page a portion of a cease and desist letter that Casey received from Janet. The complaint alleges that on December 8th, Casey published on the GoFundMe page her email response to Janet and falsely claiming that Attorney Braun filed a false copyright claim and that she was a fan of Lauren the Mortician and was not actually retained to be Ms. Propson's attorney. But that is a false statement right there, because we've seen both the cease and desist and Kitti's response. And it wasn't, you are a false attorney and a fan of, or you are a fan of Lauren the Mortician and not actually retained. It said, if you are not retained by her, you could be causing her harm. It said, if you are just a fan. It didn't say affirmatively that that's what she was. But, you know, we can't let facts get in the way of a good story, can we? It's not even a good story, though, so we will let facts get in the way. The complaint sets forth a screenshot of the GoFundMe page update from December 8th that reflects Casey's email response to Braun regarding allegations of copyright infringement. It states, in relevant part, that Casey would love further details on Janet's client and how the video had grounds for a copyright strike, as it clearly falls under fair use. I do understand how you have reached out with cease and desist to smaller content creators speaking negatively about Lauren the Mortician's scandals, and while I understand your desire to protect a creator you enjoy, if you were not legally obtained as counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. Oh, hey, look at that. An actual quote, as opposed to baseless allegations in the complaint. I mean, let's even look at the complaint again, because I want to compare them. I want to compare them. Let's just search fund. So GoFundMe. So that's, well, we do have the actual email from Kitti. But just talks about false copyright claim. And upon information and belief, defendant Casey knowingly published these statements after learning that Attorney Braun was in fact retained by Propson. Down here. So, yeah, count 2, defamation. This is dealing with the GoFundMe statements. The, you know, defendant Casey defamed the plaintiffs by publicly stating that Ms. Braun files false copyright strikes and by implying that she was acting as an attorney without being hired by Lauren the Mortician, and used her platform to attack their character and reputation. But she wasn't implying she was acting as her attorney. She just said, hey, if this is what you're doing, it'll cause her harm. There's a difference. But, you know, that difference is only important to someone who's being intellectually honest. And I don't think Janet is being intellectually honest. I don't think she's being honest, period. So, yeah. The argument. First, plaintiff's claims should be stricken under the Georgia anti-SLAPP statute. So, remember, this is brought in the alternative. So first, they're arguing the anti-SLAPP. And basically, you know, good practice if you're pleading in the alternative is the one you want the most should be the one you bring first. So they want this dismissed. Well, they want it stricken as if it never even existed, based on the anti-SLAPP statute. That's the one that would be most favorable to Caffinated Kitti. So that's the one they're bringing first. And then it's in the alternative, if you don't find this argument compelling, then 12b3 and 12b6. So the Georgia anti-SLAPP statute applies in this case. So Imuji, you asked, I believe it was you that asked earlier, wait, does the Georgia anti-SLAPP law apply here instead of the Illinois anti-SLAPP law? And I said, maybe, we'll see. Here's the argument for why it should apply. So in the case of an anti-SLAPP statute raised as a defense to the defamation claim, the choice of law question regarding the anti-SLAPP law is treated separately from whether a statement is defamatory, because the anti-SLAPP question involves whether a statement is privileged, not whether it is defamatory. That's Osendero versus Gallegos, Northern District of Illinois, 2020, which cites Underground Solutions Inc. versus Palermo, Northern District of Illinois, 2014, which itself cites Chicago versus Loyola University Medical Center, Northern District of Illinois, 2011. Pursuant to Bekah, my French is terrible, the court can apply different states' laws to different elements of the lawsuit. See Underground Solution. Although the place of alleged injury might be critical in determining the law applicable to the defamation claim, the choice of law for anti-SLAPP protection involves different interests, namely protecting the speaker's exercise of First Amendment rights, and could lead to the application of different state law. See Underground Solutions. So remember, in Depp versus Heard, the reason they filed in Virginia, and that was Virginia State Court, because both Depp and Heard were residents of California at that time, citizens of California, domiciled in California. Use the right language, Joe. There was no diversity jurisdiction, so it had to be heard in state court, not federal. But they filed it in Virginia State Court because that's where the servers were for the Washington Post, which had published the article. And Depp did not want California anti-SLAPP to apply, because California, boy, that would not have survived. But, you know, Heard, I'm sure, I didn't follow the litigation leading up to it. I'm sure she argued, hey, number one, this was decided in England, which that was a bad argument because they weren't the same issues, so they weren't precluded. But number two, this belongs in California. The judge overruled that. I'm sure in the alternative or after, she argued well, if this belongs in Virginia, then California anti-SLAPP applies because, hey, it's my right to free speech and I'm a California citizen, therefore my California rights should apply. But, you know, if she affirmatively went to Washington or, you know, reached out to Washington, she had sufficient contact with, and when I say Washington, I mean Virginia, then maybe not. But with Kitti, she made the statements in Georgia, she published them in Georgia, everything was in Georgia. So her right to free speech in Georgia should apply, is going to be the argument. So Brandon asks, is there ever a situation where a suit filed in one jurisdiction is governed by laws in another? Yes, there are. Just as an example, if there's a choice of laws provision in a contract, but not a choice of venue clause, then you know, you can sue wherever you want, where the damage was felt, but the laws stipulated in the contract are going to apply. Just as one example. So it absolutely can happen. And there's a relatively recent case where I can't remember what it was, but it happened. Well, I think it was a Cosby case, and I think it was a Cosby anti-SLAPP motion resulted in the court in Massachusetts, I think, applied the California anti-SLAPP law, if I'm remembering right, or the other way around, or I think that's what happened, but don't quote me on that. It's been a while. So, but the answer to your question is, you know, it depends, but it absolutely can happen. Whether it does happen, it depends. So, in determining which law to apply to defenses raised pursuant to anti-SLAPP statutes, courts have found the place where the allegedly tortious speak took place and the domicile of the speaker central to the choice of law analysis. And that's why we do this. It's, you know, the law is so complicated that, you know, that's why people hire lawyers. But you know, the reality is, if Illinois did have a real strong, robust anti-SLAPP provision, Caffinated Kitti might not even be arguing it, even though she could. She might, you know, let's say this had been brought in California, she might be saying, yeah, I prefer California's anti-SLAPP provision, so I'm not even going to attempt to assert my rights to be governed by Georgia law in this case, because California law benefits me. So there are entire law school classes, I didn't take it, but there are entire law school classes taught on choice of law. And that can be federal or state, or it could be which jurisdiction. It could be international. It could be, you know, does one of the international courts, you know, does the Hague have jurisdiction? Does the International Court of Trade have jurisdiction? And that's, I realize that's literally in Attorney Tom's theme song. It depends, but that's the truth. It depends. Like literally lawyers answering almost any question. If we don't start it with it depends, you know, So, and that last thing we talked about was from Intercon Solutions versus Basel Action Network from the Northern District of Illinois, which was affirmed by the Seventh Circuit, and that case applied Washington's anti-SLAPP statute when defendants were citizens of the state of Washington, and their allegedly defamatory speech, though eventually published in Illinois and on the internet, originated in that state. So that's going to be similar to here. So, and Taragi, that's, you know, a finance guide. My master's is in international banking and finance. You know, banking regulation is a nightmare. You'll find with banking regulation, though, you never get a concrete answer, but if it's an industrial bank, it's almost always going to be Utah law that applies, because Utah is one of the few states that has industrial banks, and that's why if you see like BMW Bank, that's here in Utah. Certain Goldman Sachs industrial banks here in Utah, lots of them are here because, yeah. Here, the complaint alleges that KC is a citizen and resident of the state of Georgia, and there is no allegation that the alleged defamatory speech, while eventually published on social media and the internet, originated anywhere other than Georgia. Whereas Depp versus Heard, it originated. You know, Amber Heard may have written the op-ed in California, but she published it in Virginia and Washington, D.C. That's where she published it. It was published nationwide, but it was published from the Northern District of Virginia. So, and I'm that's why, you know, lawyers, we have an ethical duty to tell the truth and to not make frivolous arguments. But the thing is, so many things, it depends that, you know, we may not fully buy the argument we're making, but if we can make it with a straight face, it's like, well, maybe this will work. Maybe this is the exception. So, and that's it. Corporations go to Delaware. They like Delaware's corporate law and tax. So, thus, Georgia has a strong interest in protecting Casey's speech, and the Georgia anti-SLAPP law applies to plaintiffs' claims against her. See Osundario and Underground Solutions and all of these. See also Amin versus NBC Universal Media, Southern District of Georgia, 2022, which held that the Georgia anti-SLAPP statute does not directly conflict with a federal rule of civil procedure and thus is substantive and can apply in federal court. So basically, they're saying here that it doesn't conflict with the federal rules of civil procedure. So it's a substantive law, not a procedural law, because in federal courts, procedural law is federal law. You don't get to apply state procedural law in federal court on diversity cases, period. But you do get to apply substantive law. So substantive law would be the, you know, the defamation statute. Well, defamation isn't a statute. Generally, it's common law. But, you know, it's what you're in court for. How it proceeds through court is the procedural law. So I didn't explain that very well, but that's okay because we are, and it's good to have you here in real time, Sarah J. I hope that your dinner was nice. So, Casey's statements constitute a protected activity under the Georgia anti-SLAPP statute. Under Georgia law, the analysis of an anti-SLAPP motion to strike involves two steps. See ACLU versus Zay 2021, and that's Georgia Supreme Court, I believe, 2021, citing Wilkes versus McHugh versus LTC Consulting, also Georgia Supreme Court 2019. First, the court must decide whether the party filing the anti-SLAPP motion has made a threshold showing that the challenged claim is one arising from protected activity. So basically the first step is Caffinated Kitti has to show that what she did was protected activity. So Katie Gray, once again, it depends. It depends. So there is the supremacy clause in the Constitution. The supreme law of the land is the Constitution, the federal laws passed thereunder, and treaties. But that's only in areas where the federal law applies. So, in federal court, if the federal rules of civil procedure apply, but in state court they don't. In state courts, the states aren't precluded from making their own rules of civil procedure. And the common sovereign citizen argument that hey, look, there's this one federal law about commercial drivers and and that's the only place that the federal law regulates drivers. Therefore, this supersedes federal law, except it doesn't, because they're different. So it and that's sometimes the states can be more stringent, but sometimes they can't. If federal law, the feds have exclusive jurisdiction over copyright, over most of bankruptcy, so they're only they get to, but those are only heard in federal court anyway. So it's a mess. It's a mess. We could be here all night. It's a mess. But so yeah, first they have to make a threshold showing that the challenged claim is one arising from protected activity. That's from Wilkes, quoting OCGA section 9-11-11.1 B1. If so, the court must then decide whether the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. So first, decide whether this is a threshold matter for which the SLAPP provision applies, and then whether or not, hey, can the plaintiff even win on this? And it's not can they win, it's a probability that they will win. So to me, that sounds, clear and convincing. I could be wrong, but that's what it sounds like to me. And remember, we discussed this last time, clear and convincing, much higher than preponderance, lower than reasonable doubt standard. A protected activity under section 9-11-11.1 Point 1 is one which could reasonably be construed as an act in furtherance of the person's or entity's right of petition or free speech under the Constitution of the United States or the Constitution of the State of Georgia in connection with an issue of public interest or concern. The code section defines an act in furtherance of the person's or entity's right of petition or free speech under the Constitution of the United States or the Constitution of the State of Georgia in connection with an issue of public interest or concern to include any written or oral statement or writing or petition made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other official proceeding authorized by law. Any written or oral statement or writing or petition made in a place open to the public or a public forum in connection with an issue of public interest or concern, or any other conduct in furtherance of the exercise of the constitutional right of petition or free speech in connection with a public issue or an issue of public concern. So that was a whole lot of what counts. And I think that last one, well, the last two are the ones that count. So conduct in furtherance of the exercise of the constitutional right of petition or free speech in connection with a public issue or an issue of public concern. So, yeah. And Teragi, that's a whole mess. Basically what Teragi is talking about is, since marijuana is illegal at the federal level and banks are regulated under the feds, marijuana dispensaries in states where marijuana is legal don't have access to banking. So they keep a lot of cash on hand because it's all cash transactions. And that makes them targets of robberies, which is not good. And that's one of the goals of legalizing marijuana is, take the crime out of it. But because they're not allowed access to banking, it keeps the crime there. So, yeah. The statute is intended to protect persons exercising their constitutional rights of petition and freedom of speech. To accomplish this goal, the statute is to be construed broadly, whereas in Illinois, it's very, very narrowly construed, at least now. It used to be broadly construed, but yeah. With respect to both plaintiffs' claims against KC, there can be no question that they are based on statements made by KC in a public forum in connection with a public issue or an issue of public concern. The complaint alleges that the statements were made in videos posted on social media platforms, including TikTok, as well as an online donation platform called GoFundMe. The complaint also alleges that the videos containing the alleged defamatory statements were viewed approximately 928,000 times and over 263,000 times, respectively. Social media and online platforms are considered public forums for purposes of anti-SLAPP statutes. CEG, Equity Prime Mortgage versus Green for Congress, Georgia Court of Appeals 2022, which held that statements made on social media fell within the scope of the Georgia anti-SLAPP law. To determine whether an issue is an issue of public concern under the statute, courts consider whether the subject of the speech or activity was a person or entity in the public eye or could affect large numbers of people beyond the direct participants, and whether the activity occurred in the context of an ongoing controversy, dispute, or discussion, or affected a community in a manner similar to that of a governmental entity. So basically, what that's saying is, if I were in my backyard with my brother and niece, just as an example, and I shouted, but they were the only ones that could hear me. If I shouted, Lauren the Mortician is a TERF, and they were the only ones that heard me, well, that was about someone in the public eye, but my statement couldn't affect large numbers of people beyond, me and my brother and niece. So the anti-SLAPP provision probably wouldn't count. Now, of course, what was it sufficiently published? Maybe, but I wouldn't get sued anyway because Lauren the Mortician wouldn't know about it. But by doing it online like this, hey, it's open to everyone. So it does have the ability to affect large numbers of people beyond the direct participants, and that's once again a big discussion that it just, once again, it depends how the courts decide if someone's a public figure, and it's going to depend by jurisdiction, and we'd spend way too much time on that. So basically that's me saying that's a good question, but we don't have time today. So, and that quote was from Amon versus NBC Universal Media, citing Lane Dermatology versus Smith, which was Georgia Court of Appeals 2021, saying an issue of public interest is any issue in which the public is interested. In other words, the issue need not be significant to be protected by the anti-SLAPP statute. It is enough that it is one in which the public takes an interest. See Cross versus Cooper, California Court of Appeals 2011, as modified on denial of rehearing, August of 2011. So, as to Propson's claims, the complaint alleges that Propson maintains a famous social media persona with millions of followers on TikTok, as well as sponsorships and a brand partnership with a famous documentary channel. Thus, she certainly is in the public eye. The complaint also alleges that Casey explained that her statements were made as the result of confusion between Casey and Propson by social media followers, and Casey did not want to be confused with a social media persona with millions of followers who liked transphobic and hateful rhetoric. Thus, the public issue implicated by Casey's alleged statements is the confusion between two social media personas who are undoubtedly in the public eye, one of which has liked and followed other social media personas whose content contains transphobic and hateful rhetoric. Whether Propson, who has millions of social media followers for her educational videos about death and the loss of loved ones, likes and follows other social media personalities who post transphobic and hateful rhetoric, is certainly a matter of public interest, particularly when the public is confusing Casey and Propson. That's Rosser versus Clyott, Georgia Appeals Court 2018, holding that statements made regarding former president of a corporation in connection with a controversy that would affect more than 13,000 members of the corporation is of legitimate public concern. That was citing Buckley versus DirecTV, Northern District of Georgia 2003, which said any action involving such a large number of people is, by definition, a matter of public concern. And I missed where footnote 2 was raised, but it says, Georgia courts have expressly looked to California case law interpreting the California anti-SLAPP statute for guidance in interpreting the Georgia anti-SLAPP statute, given that California anti-SLAPP statute is very similar to the text of Georgia's revised anti-SLAPP statute. And that was in Wilkes versus McHugh, or Wilkes and McHugh versus LTC Consulting. So, yeah. And this, not much to say other than this is good. As Brittany says, all the receipts there, this is why the law applies according to Caffinated Kitti. But it's, you know, a bit of life advice for Lauren the Mortician. You know, if you're going to be liking posts from controversial figures, if you're even going to be looking at posts from controversial figures, don't do it on your public persona. I mentioned Facebook and how I rarely see my friends, but I'm of the age that is my social media. You know, I signed up when you had to be a college student to sign up. That's just, you know, it's what I used for socializing in grad school. So, but my profile, number one, you're not going to see my face because I don't use my face as my profile picture. It's not quite a ghost profile, but it's pretty locked down from public view, unless they've changed it, because Facebook has a tendency to change your privacy settings. But, you know, if I'm liking things that are controversial, only my real life friends are seeing it. You guys aren't. So, you know, if Lauren wants to be liking this conservative aunt's profile, she should have her own browsing personal profile that isn't linked to her public persona. She should have a Lauren Propson or just Lauren or whatever TikTok account where she can watch all the controversial stuff she likes and like it and share it and whatever. And it doesn't have to affect her public monetized persona. And Teragi is much, much more succinct than I am. Girl, get an alt account. It's not that hard. It's not that hard. My YouTube watching is, frankly, it's not controversial, but it's not on this account that you guys are watching me on. It's on my personal account that I've had for, well, almost since the start of YouTube, which, like I've said before, for the first 10 or 12 years of YouTube is exclusively a music delivery system. And yeah, but get an alt account so that what you do on that doesn't impact your public persona, unless you let it, because, you know, some people are dumb and have their alt accounts identifiable, tied to themselves, and that's just dumb. As for Braun's claims against Casey, that Braun being Janet, once again, they are also based on protected activity by Casey. Namely, Braun's allegations are based on purported statements that Casey accused Janet of filing a bad faith copyright strike or complaint under the DMCA against Kitti, i.e., the filing of the DMCA copyright strike complaint was unfounded or in bad faith because Casey's use of Propson's alleged copyrighted material constituted fair use. As explained above, the Georgia anti-SLAPP provision provides that any written or oral statement or writing or petition made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or, and this is bold italics, any other official proceeding authorized by law is deemed a protected activity under the Georgia anti-SLAPP statute. This statute creates an expansive definition of protected speech that includes any statement made in connection with an issue under consideration by any official proceeding. That's Johnson versus Courts, Georgia Appeals Court, 2022. Of course, with emphasis added. That could be fun. That could be fun, addressing the Janet allegations. And Katie Gray, it absolutely is already public. It is right here. It's this tab I have open up here that I have a feeling we're not going to get to tonight because I am slow. But that's what you guys are here for, is me being slow and verbose and obnoxious and bad puns. So I'm really anti-dad joke because in my day they were just called puns. And I'm not a dad, but I make them. The filing of a complaint or copyright strike under the DMCA constitutes an official proceeding as it is expressly authorized by law. That's Kibler versus Northern Inyo County Local Hospital District, California, Supreme Court, 2006. And remember, we saw case law saying, hey, California case law is more than just persuasive. We apply a lot of it here in Georgia because our anti-SLAPP laws are pretty much the same. So even though it might only be persuasive, you know, it might actually be good law. We should maybe be taking it into consideration. So that, just a reminder, that's why we're seeing California citations. So, and that Kibler case held that hospital peer review constitutes an official proceeding under anti-SLAPP law because it is authorized by California Business and Professions Code, Section 805, etc. So, see also Laker versus Board of Trustees of California State University, California Court of Appeals 2019, which held that investigations by State University into employee allegations of workplace misconduct were official proceedings authorized by law that received the protections of the anti-SLAPP statute because the university had statutory authority under the California Education Code to make rules governing employees and to respond to complaints of workplace misconduct. Here, the DMCA specifically authorizes and outlines the procedure for the filing of a complaint or copyright strike with an online service provider. See 17 USC section 512C3. So that would be part of the DMCA, I believe it's federal copyright law. And Brittany, so people, and by people, I mean Runkle, because he's the only one I have seen cover it already. So Kitty's was filed early as an example. I don't think you were here at the beginning. So it's too big for the normal rules. It's too many pages. So on the 26th of February, they filed a motion to file excess pages. So basically saying, hey, court, can we file a motion that's longer than you generally allow? And, oh, by the way, here's the proposed motion. So that's what Ian Runkle looked at. Now, someone else may have looked at the actual motion, but that was before they were due. The actual motions were due on the 29th. So yesterday. And so all of them, including Caffinated Kitti's actual motions, were filed yesterday. So thus, it constitutes an official proceeding authorized by law, and KC's alleged statements made in connection with that official proceeding, i.e., it was filed in bad faith, is protected under the Georgia anti-SLAPP statute. Furthermore, the statements are also protected as public statements of a public issue or public concern under the Georgia anti-SLAPP law. Again, the complaint alleges that Propson has millions of social media followers. Thus, whether she has hired an attorney to file copyright claims and or strikes against content creators simply because they post content that Braun's clients, including Propson, do not like, is a matter of public concern and interest. That's citing the ACLU case, which held that a blog post asserting that a public defender had charged an indigent criminal defendant a fee for public defense services was a protected activity under anti-SLAPP statute. Because KC's statements are protected activity under the anti-SLAPP statute, KC has satisfied the first step of the anti-SLAPP inquiry as to both plaintiffs. Remember, the first step, you've got to show that your alleged speech was of the type considered by the anti-SLAPP law. And then you have to show that there's no probability that the plaintiff will win. So that's our next section. There is no probability that plaintiffs can prevail on their claims because they are legally deficient. Once a defendant has established that the claims asserted against it arise out of protected activity, as Caffinated Kitti has done here, the burden then shifts to the plaintiff to demonstrate that there is a probability that the plaintiff will prevail on his or her claims. See the Georgia anti-SLAPP law. In federal district court, an anti-SLAPP motion may be premised on legal deficiencies inherent in the plaintiff's claim, analogous to a motion to dismiss under Federal Rule of Civil Procedure 12b-6. Maybe Janet can change Braun law to legally deficient. Good description for her term. She can team up with Mr. Lockyer. Not that Mr. Lockyer's a terrible attorney or anything. It's just my opinion that he is. So basically, they're saying this is like a 12b-6 motion, but the burden has shifted to the plaintiffs. So burden shifting. Normally, well, so the burden is on the plaintiff to show that they have a case. So if they don't bring a valid cause of action, they don't win. It's their burden of proof. But in a SLAPP suit, basically, it's your motion as the defendant. So you have the burden to show you're entitled to relief. But the burden is on the defendant to show that, hey, we have to show A, that this is the type, it's these claims arise out of protected activity. Then the burden shifts, and it's basically the plaintiffs have to bring in, the reverse of a 12b-6 motion and say, but we'll win because our claims are that good, is basically what they're saying. So it's analogous to a motion to dismiss under 12b-6. And if a defendant makes a special motion to strike based on alleged deficiencies in the plaintiff's complaint, the motion must be treated in the same manner as a motion under Rule 12b-6, except that the attorney's fee provision of the anti-SLAPP statute applies. That's Planned Parenthood of America versus Center for Medical Progress, 9th Circuit, 2018. See also Osundaro, which is a district court case or a state court case. In determining whether a complaint satisfies Rule 12b-6, the court accepts the facts stated in the complaint as true and draws reasonable inferences in plaintiff's favor. That's Parrish versus City of Elkhart, 7th Circuit, 2010. Though a complaint need not contain detailed factual allegations, a formulaic recitation of the elements of a cause of action will not do. That's from Twombly, the Supreme Court case from 2007, along with Iqbal from 2009. Those are the cases on 12b-6 and the sufficiency of pleadings. Rather, the complaint must contain enough facts to state a claim to relief that is plausible on its face. A complaint fails to state a claim where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct. That's Iqbal. Here, as explained below, plaintiffs have failed to state facts sufficient to constitute any cause of action against Caffinated Kitti. Thus, each of the claims should be stricken under the anti-SLAPP provision, and attorney's fees under that statute should be awarded to Caffinated Kitti. Braun, that's Janet, cannot prevail on her defamation claim. To state a claim for defamation under Illinois law, that's footnote 3, under Illinois law, the law of the state where the injury occurred governs the substantive issues of the case. That's Townsend versus Sears Roebuck from the Illinois Supreme Court in 2007. And in the case of defamation, that is the state in which the plaintiff is domiciled. See Camelgard versus Mercura, 7th Circuit, 2009, which is a collection of cases. So basically they're saying, hey, this is more choice of law. Well, determination of law provision. So here, the anti-SLAPP provision for Georgia should apply because Caffinated Kitti made the statements in Georgia. But for the 12b-6, for the substantive law of defamation, Illinois law should control, because that it's not where was the statement made, but where was the injury felt. So going back to Brandon's question earlier, is there a case where, you know, the one state's court will have to use another state's substantive law? I think this is what the Cosby case actually was. It wasn't about SLAPP. I think it was about defamation, and so I think Massachusetts is where the case was heard, because that's where they had personal jurisdiction over the defendant, but they had to apply California's defamation laws, if I'm remembering right. So let's say, you know, Schofield versus Guillard. Let's say Professor Schofield had brought the case in Texas. Then if she had done that, Idaho's law, because the injury was felt in Idaho, Idaho's law would have controlled Idaho's defamation law. So the Texas court, having personal jurisdiction over Ashley Guillard, would have had to use Idaho substantive law. So here, Illinois law controls for defamation, not for anti-SLAPP. But The reality is, South Carolina law probably should apply, but we're pretending that Janet actually is domiciled in Illinois, at least for now. So, to state a claim for defamation under Illinois law, a plaintiff must plead facts showing 1. The defendant made a false statement concerning the plaintiff. 2. There was an unprivileged publication of the defamatory statement to a third party by defendant. And 3. Publication of the defamatory statement damaged the plaintiff. And that's Brennan versus Kadner, Illinois Court of Appeals, 2004. Here, the complaint alleges that KC defamed Braun by publicly stating that Ms. Braun filed false copyright lawsuits and by implying that she was acting as an attorney without being hired by Lauren the Mortician. And she used her platform to attack Janet's character and reputation. The complaint also alleges that KC stated that Janet filed bad faith copyright strikes against her and that Janet was accused of being an unethical lawyer that files frivolous copyright claims. As a preliminary matter, this is polite legal speak for first of all, as a preliminary matter, the allegation that KC defamed Braun by using her platform to attack Janet's character and reputation does not state a claim for defamation under Illinois law. Defamation per se must be pled with a heightened level of precision and particularity. This heightened standard is premised upon an important policy consideration, namely that a properly pled defamation per se claim relieves the plaintiff of proving actual damages. And that's Green versus Rogers, Illinois Supreme Court, 2009. See also Osundaro, which held that plaintiffs do not identify any particular statements that forms the basis for this allegation. This imprecision leaves defendants and this court guessing as to which statements are at issue, and it dismisses claims of defamation per se and false light based on the allegation for lack of specificity. And here, Janet was pretty unspecific in her claims. She was vague. Thus, the vague allegation that Casey attacked Braun's character and reputation without precise identification of the actual words used cannot state a claim for defamation. And the reason Janet doesn't use the actual words that Caffinated Kitti used is because the actual words don't constitute a claim that Janet can make, because the actual words were, if you are not, I realize you may be a fan, but if you are not actually retained, you are going to cause her harm. That's not a statement of fact that you are a deranged fan and you are a rogue attorney. It's saying, friendly advice. If this is what you're doing, you're going to cause harm. But because that doesn't help her, she's vague. As for the allegations that Kitti defamed Janet by stating Janet files false copyright lawsuits or bad faith copyright strikes or claims, they are also patently defective. As a preliminary matter, both the 1123 TikTok posts and the GoFundMe website referenced in the complaint make clear that Caffinated Kitti is of the opinion that Braun has no grounds to file a copyright strike against her. A transcript of the TikTok posts reveals that nowhere in the TikTok posts does Caffinated Kitti actually state that Janet filed bad faith or false copyright claims or copyright strikes against her. Rather, the only reference to the copyright strikes filed against Casey by Janet in the TikTok post is Casey's statement that she found the copyright strike to be bizarre. In footnote 4, while the complaint reflects an alleged screenshot from the November 21st, 2023 TikTok post with the text "in bad faith copyright infringement strikes" imposed over an image of Casey, that text is not referenced in the video itself, a link to which plaintiff failed to include or cite in the complaint. Moreover, nowhere in the TikTok post or the GoFundMe page does Casey state that the copyright strike filed against her was in bad faith or accuse Braun of being an unethical lawyer who files frivolous copyright claims. And thus, Braun has failed to allege with adequate particularity the statements that form the basis for the defamation and false light claims against Casey based on these specific allegations. Because once again, we went back to the complaint earlier in this video and we looked at this exact image they're referencing in footnote 4. Because in the text of the complaint, it's just these vague assertions that, well, she says I'm a bad attorney that makes false claims. Wah. But that's not good enough. That's not good enough. Likewise, the screenshot of the GoFundMe page posted by KC reveals a letter from KC to Janet with the subject line "false copyright claim" and states only that KC and her team would love further details on your client and how the video had grounds for a copyright strike, as it clearly falls under fair use. A party who has been sued or otherwise had a legal proceeding instituted against him or her is certainly permitted to express their disagreement with the merits of the proceeding without being liable for defaming and opposing counsel. As such, a statement is a non-actionable opinion. Unless you're Janet, of course, because then you get to say, hey, your video violated my client's copyright. I don't have to tell you why it violated her copyright because that's attorney-client privilege. But believe you me, I conducted the analysis, and only I am capable of conducting that analysis because I am a federal civil attorney and you are just a plebeian TikToker. So you're incapable of doing that analysis. And even if you did that analysis, it would be wrong because you're not a federal civil attorney. And when YouTube sends counter notifications on CC Suarez's video saying, so about this copyright strike you made, we don't think that it's valid. We think that CC Suarez's video was fair use, even though Google has an entire legal department full of high-priced attorneys who are much better than Janet. YouTube is not a judiciary, so therefore they're not allowed to have an opinion. Only federal civil attorney Janet is entitled to an opinion. Her analysis stands. She is the sole purveyor of fair use. Now, I can't remember. It was in law school. I think we had a speaker who was one of the higher ups. It wasn't Google. It was, I think it was Shell Oil. One of their general counsels was a graduate of my law school. And by Shell, I mean Exxon. I think he was Exxon. And he told us, if Exxon's in-house legal department were to split off as a independent law firm, it would be like the 4th largest law firm in the world. It had that many attorneys. Google would be in a similar situation. They have hundreds of attorneys at Google. We had a speaker in one of my classes. I think it was Intel. It was a Silicon Valley bigwig, and he was the general counsel. I think it was Intel. He was also a graduate of the U, and it was interesting. He this was at the time when a new iPhone had just come out, and it was supposedly unhackable. You couldn't force your way in, and the U.S. government wanted their way in. They got a search warrant and said, "Hey, Apple, let us in." And Apple said, "Nope." And this general counsel for one of Apple's peers in Silicon Valley, he had regular meetings with all of the other general counsel of Silicon Valley mega companies. He said, Apple would actually love to break into the phone for the US government. They'd love to comply with the warrant. The reason they are not doing it is because of China. They do not want China to think that they can do it, because that could just make problems for Apple doing business in China. And that is why Apple won't give a backdoor to the FBI. So I realize that's not relevant to this. I just, little aside that came to mind because talking about Google's army of high-priced, very good lawyers. We've seen in DeCastro versus Abrams, where he brought in YouTube as a defendant. They used Wilson Sonsini as their retained counsel. Wilson Sonsini being one of the absolute best law firms. So Janet thinks she gets to dictate to YouTube what fair use is and how their copyright takedowns are going to work under the DMCA. Janet is not very good. They very well might be seeking a general consensus sometimes. So a statement, getting back to the task at hand, a statement is constitutionally protected opinion if it cannot reasonably be interpreted as stating actual facts about the plaintiff when viewed from the perspective of an ordinary reader. That's Doctors Data Inc. versus Barrett, Northern District of Illinois, 2016. Because remember, even though for the SLAPP portion, Georgia law applies with some California case law applying because Georgia applies California case law for SLAPP. Illinois law applies for defamation because that's where the injury was allegedly felt. So to determine whether a statement is factual in nature, Illinois courts consider whether the statement has a precise and readily understood meaning, whether the statement is verifiable, and whether the statement's literary or social context signals that it has factual content. It's getting a little warm in this room. If it is clear that the speaker is expressing a subjective view or interpretation, subjective, opinion would be subjective, such as when the speaker discloses the facts forming the basis for the statement is not actionable as defamation. Here, it is clear that Casey is expressing her subjective opinion that the copyright claim had no grounds, based on her opinion that the defense of fair use is applicable. Furthermore, use of the term false or even bad faith, assuming Caffinated Kitti even used that phrase, has no precise and readily understood meaning. See Solaya Tech versus Specialty Publications Company, Illinois Supreme Court 2006, which found the phrase deeply greedy people has no precise meaning and it is not verifiable. Further, the context in which that phrase appeared indicates that it may have been judgmental, but it was not factual. This statement is not actionable. The terms false or bad faith are so broad in scope that they lack the necessary detail to have a precise and readily understood meaning required to be actionable. See Hopewell versus Vitulo, Illinois Court of Appeals, 1998, which held that the term incompetent is non-actionable opinion because there are numerous reasons why one might conclude that another is incompetent. One person's idea of when one reaches the threshold of incompetence will vary from the next person's. Like here, Caffinated Kitti's opinion of what a false copyright strike is may differ from Janet's opinion of what a false copyright strike may be. Wow, it's not actionable. It's not actionable. And that's good. That's good. Whether Janet is incompetent is a matter of my opinion. And my opinion of where Janet's incompetence lies differs from Janet's opinion of where incompetence lies. The only opinion that matters is the Illinois bar's opinion of what incompetence is. And the Illinois Supreme Court as well, as they're the ones that would disbar her if she were to be found incompetent. So, yeah. See also Tamburo versus Dworkin, Northern District of Illinois 2013, which held that statements that plaintiff's actions were unethical and deceitful are plainly subjective, not objectively verifiable, and not actionable. Wow. Taragi, I think if you are typing this already, I think you'll enjoy that one. Unethical and deceitful. How appropriate. Boy, this is a fun motion here. I debated which one to do today. I thought about finally doing the Ruby Frankie stuff. I thought about catching up on delete laws. I'm glad this is the one that I did because it is fun. And that's it. Janet, to me, is shady as hell. Mr. Lockyer is not very good. I don't know if Janet has something on him, if they're best friends from law school, if he's doing it cheap for her. But I get the ick from both of them. But I'm a fan of this lawyer whose name I can't remember. He's a pro hoc vice. He's from California. So, yeah. This has been a fun one. What does it mean for a claim to be false or in bad faith? And how would one verify that? Courts can and do routinely disagree over whether particular claims have merit. To hold Casey liable for expressing her opinion regarding the merits of the copyright strike filed against her by Janet would open any litigant up to liability for defamation if they spoke publicly regarding the merits of the proceedings filed against them. That is not and cannot be the law. I don't know. I believe she should be, because the wellness checks she called against Caffinated Kitti, I believe, number one, were criminal, and number two, were unethical. I believe her being a co-plaintiff with a client of hers is unethical, and I believe the Illinois bar should be investigating her. Now, the problem with that is I can't say whether they are, because, as has been pointed out, I think it was Mad Catster, but bar complaints are private because, you know, attorneys get complaints all the time. Most of them are frivolous because, you know, a client doesn't like the way you do something, they're going to complain. The opposition doesn't like the way you did something, they're going to complain. So, you know, you can't let false complaints ruin your reputation. So until something happens with them, they're private. So I think the Illinois bar should investigate her, but until it's disclosed, I can't say that they are investigating her. But that's a good point, Teragi. Her saying, I'm a federal civil attorney. Well, to lots of people, you say, I'm a federal attorney, they're going to think, oh, where do you work in the DOJ? Are you an assistant U.S. attorney? Are you a bankruptcy trustee? Are you a tax examiner? What do you do for the federal government? Like I've said, I'm currently not licensed in federal court. I just have to pay like a $25 fee and re-up my license. I have practiced in federal court a little bit, but it's something to put on the resume. You say, yeah, I'm allowed to appear in Utah Federal District Court or whatever, you know. She thinks she's trying to big herself up in front of the non-lawyers, and she thinks it, this is my opinion, she thinks it's more intimidating to people like Caffinated Kitti saying, I'm a federal civil attorney. That means you're going to be in federal court if you piss me off. And federal court is more scary than state court, even though, you know, I actually kind of disagree, because state court is like the Wild West in some respects. Federal court is more of a known entity. But like I said, it could be interpreted as she's trying to imply that, especially when she called in the wellness checks to the 911 operator, I'm a federal civil attorney. That's trying to add weight to her statement saying, hey, you better take this wellness check seriously, because you know, the DOJ is the one making it. So it's not a good thing. It's not a good thing to be making. And so they could censure her for it or do something, you know. Will they? Probably not, but they could. Finally, Braun's allegation that Casey defamed her by implying that she was acting as an attorney without being hired by Lauren the Mortician is also a non-actionable opinion. Both the transcript of the TikTok posts and the GoFundMe page make clear that Casey thought that Propson may not have hired Janet as her attorney. See the transcript exhibit, which says, so when this first started to the attorney, I didn't think that it was actually someone Lauren hired. So, like I said, I thought Janet had just gone rogue and not been actually hired. See also the complaint, which said, while I understand your desire to protect a creator you enjoy, if you were not legally obtained as a counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. And Janet, that's also not blackmail. I know you needed to hear that, Janet. It's not blackmail. If it is clear that the writer is exploring a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts, the statement is not actionable. That's Moriarty versus Green, Illinois Court of Appeals, 2000. And that reminds me, it's not explicitly stated in Sherlock Holmes, but Professor Moriarty went to my university. It's generally accepted. Moriarty went to Durham University. In Sherlock Holmes, it says he was a graduate of a top northern university or the top northern university or something like that. That's generally considered Durham. So, arch villain, Professor Moriarty, fictional alumnus of my university. And Moriarty cited Haynes versus Alfred A. Knopf, 7th Circuit, 1993. See also Brennan versus Kadner, Illinois Appeals Court, 2004, which found non-actionable opinion when statement was not couched in terms of factual assertion, but rather as conjecture. So if you were not hired by Lauren the Mortician, you'll cause her harm. If you were not, that is conjecture. But it's also a factual statement that, hey, if you were not hired by her, you're going to cause her trouble. That part is a factual statement. But as to her not being hired, it's opinion. Twombly does not have an E, and Iqbal is Arabic, so it's Iqbal. But yeah, the legal world is full of terrific names. Mine would clearly be way too boring for a landmark legal case. If I ever create a consumer brand, a fancy luxury brand, I would not use my actual name. I'd use a derivation of my first name, but I'm named after my gross opa, so it would be that derivation of our shared first names and his last name, which is a Germanicized Czech name. He was a Sudeten Czech. They all became German in 1933 because of world events. But he was from what at the time was called Marienbad. It's now Mariansky, right on the border, on the Czech side of the border from Germany. Luxury, tourist town. Anytime you see Bad in the town name in the German-speaking world, you're going to think Bad is spa. So, Baden-Baden, famous German spas. Marienbad, famous Czech spa. So, yeah. I mean, the thing is, Brandon, if I were to get a large following and, between the various channels I want to do, instead, I'd take, paid promos. There's some that I wouldn't do. Like, I hear really bad things about BetterHelp. I don't think I'd take them as a sponsor, but eventually I'd want to do my own. And, the second or third richest person in the world, depending on how things fluctuate, is Bernard Arnault, Frenchman. He owns LVMH Hennessy or Moet. whatever. So he owns Louis Vuitton, Hennessy, basically all the luxury brands, and that's made him worth $200 billion. And you see, like, George Clooney, what's his tequila called? In my mind, I'm thinking Tres Hombres or something, but that's a local Mexican restaurant. Or Aviation Gin by Ryan Reynolds. That they sold those for $1 billion each. So it's like, even though I don't drink, it's like, do a super luxury liquor line and fashion and stuff, and have that exotic Central European name as my moniker, because my actual name isn't all that exotic, especially here in Utah. So, moreover, social contexts are a major determinant of whether an ordinary reader would view an alleged defamatory statement as constituting fact or opinion. And that's Brennan versus Cadner, Illinois Appeals Court, 2004. The fact that these statements were made on the internet and social media posts further underscore that they constitute an opinion. And that's footnote 5. Courts have emphasized the generally informal and unedited nature of statements made on the internet. See Gansky versus Mensch, Southern District of New York, 2020, citing Sandals Resorts International versus Google, First Department, 2011. The culture of internet communications, as distinct from that of print media, such as newspapers and magazines, has been characterized as encouraging a freewheeling and anything-goes writing style. Social media platforms are equally, if not more, informal and freewheeling, and as such convey a strong signal to a reasonable reader that a statement is opinion. And that was referring to statements on Twitter. So basically, this contradicts the well-known quote from Abraham Lincoln that if you read it on the internet, it must be true, because Abraham Lincoln was a lying Yankee, at least about the internet. But here, we've got the court opinion saying, hey, if you read it on the internet, it probably should be taken with a grain of salt, maybe with a mountain of salt. It's people use hyperbolic language on the internet. People express their opinion on the internet. Unless they say, it is a fact that Janet is an unethical lawyer because of this. And it is a fact that Lauren the Mortician absolutely hates trans people because of this. You'll notice Lauren and Janet, I'll slow down for you. I said I used that as an example. I used statements of fact, but they were not my statements of fact. I said, unless someone said something like this. If someone says, hey, if you aren't her lawyer, you're going to cause her problems. That's not a statement of fact to start with, but it's also on the internet, which is freewheeling. It's the Wild West, anything goes writing style. So it should probably be interpreted as a friendly warning that, hey, you shouldn't mess with people. Not only are Caffinated Kitti's statements about Janet non-actionable opinions, but they are also subject to a qualified privilege under Illinois law. Hey, where have we heard the phrase qualified privilege before? Oh, yeah, from Ashley Giard. She tries to assert that she has a qualified privilege to defame Professor Schofield. But let's read about this actual probable qualified privilege. Such a privilege may exist where the situation involves an interest of the person who publishes the defamatory statement or an interest of the person to whom the matter is published. So in this case, we can distinguish this from Ashley Giard because in this case, the copyright strike was made against Caffinated Kitti's own video. And she was making the statement about the person who did strike Caffinated Kitti's own video. So where the situation involves an interest of the person who publishes the statement or the interest of the person to whom the matter is published. So the allegedly false copyright strike is a matter of interest to Caffinated Kitti and about Janet. So therefore, there may be a qualified privilege. Whereas, let's contrast that with Ashley Giard. Ashley Giard tried to say, there's a qualified privilege for me to say that Professor Schofield is a murderer. And that qualified privilege is the litigation privilege. Because there is a criminal case ongoing against Brian Kohberger, I can't be prosecuted or I can't be sued for saying that Professor Schofield is the actual murderer. Well, there's no privity to the Brian Kohberger case for Ashley Giard. She's not involved in it. She's not a witness. She's not a participant. She is not a defendant. She is not the prosecutor. So she doesn't have an actual interest in that case. And when I say actual interest, I don't mean, yeah, I'm interested in that. That's fascinating. I mean, like a proprietary interest. She's not a participant. So she didn't have any qualified privilege. Now, to talk about the case Schofield versus Giard, that qualified privilege might exist. But she's being sued for statements that were made before that litigation. The litigation is about those statements. So, and that, so is your name Hispanic? Is it Relana or Rayana? But if the case goes to discovery, could Caffinated Kitti request copies of the DMCA strikes that Janet sent to show the court? It's very possible she might already have them. Like, if they were made on YouTube, she'd already have them because YouTube gives them to the struck person. I don't know on TikTok or Facebook. I've never received a copyright strike on YouTube either. But like we've seen, because Cece Suarez has shown, I still want her to send them to me, but Cece Suarez has shown the cease and desists that Janet has sent her and the DMCAs that Janet did on YouTube, and they were terrible. And yeah, they'd absolutely be discoverable and go to the court. And that discovery would be great. It would be fun. But it would also be very expensive. So I'm hoping that the SLAPP motions and Bekah Day's motion to dismiss, because she's in Missouri, and so they're not bringing an anti-SLAPP for her. At least it didn't look like it. You know, we don't want them to have to pay extra just so that we get the satisfaction of seeing some discovery. We want it dismissed now, and we want fees awarded, because I believe this is a SLAPP suit. So that last citation was Tamburo, and it also says, courts also recognize as privileged communications involving a recognized public interest. Whether a qualified privilege exists is a question of law for the court. Cases, so, question of law. So, if in the complaint, I don't think they did, but let's say Janet had said, this is an unprivileged communication, which she might have, but that's not given the assumption of truth, because that's not a factual allegation. That's a conclusion of law. And here it says it's a question of law for the court. So it's not given the assumption of truth in the complaint. Casey's statements are privileged because they relate to her interest in protecting her freedom of speech in her social media posts and in not being subject to DMCA copyright strikes filed by Janet in response to statements made on social media with which Braun's clients disagree. Moreover, the statements made by Caffinated Kitti were published to those who share that interest, i.e., other individuals who have social media accounts who have been or could be subject to DMCA copyright strikes filed by Braun. Who could that be? Jamie Grayson? CC Suarez? Whoever the hell else? And the reality is, Linux guy, this attorney, I can tell you, I haven't actually looked him up. He's not cheap. California attorneys are not cheap. Attorneys of this quality are not cheap. And speak of the devil, hello, Jamie Grayson. It's good to see you. It's, I don't know how long you've been here, but this has been a fun document. I mean, I think the Beach Boys actually did sing about it. Fun. Funny enough, the song Fun occurred very close to my house. It's based on a true story. So the teenager who was out driving her daddy's T-Bird, the daddy was the owner of a local radio station here in Salt Lake City. And the Beach Boys loved coming to Salt Lake City back in the early 60s. They were here all the time. They referred to it as their second home. They even wrote the song Salt Lake City about how much they loved coming here. But the owner of the radio station had the Beach Boys in the studio that morning, and he was telling them about how he had just had to take away the T-Bird from his daughter, and they wrote a song about it. The song Fun. And the hamburger stand she allegedly drove it to instead of the library was on 33rd South and I think 29th East. It's no longer there, but I drive by that intersection all the time. So just since I said fun, figured I'd bring that bit of completely irrelevant trivia. But either way, like I said, Jamie, this has been a real fun document, and there's 2 more to go, and we're not going to finish all of them tonight because I'm slow and verbose and have too many tangents that I'm going off on. But as you can tell, I'm having fun, so that's why I'm doing it. So let's find it. So there were a whole bunch of citations for that, including Ludlow versus Northwestern University, Northern District of Illinois, 2015, where that case said, once qualified immunity has been identified, a plaintiff may overcome this challenge at the pleading stage by alleging the statement was made with actual malice, either knowledge of its falsity or in reckless disregard of the truth. So here, Janet, well, number one, Janet might be a public figure, so she might have to be pleading actual malice anyway, but to survive this claim of qualified privilege, which they said in that case, qualified immunity, is wasn't made with actual malice. So Kitti saying, well, are you actually her lawyer? You know, because if you're not, you're going to cause her problems. That hardly constitutes actual malice. I mean, it's not defamation anyway, but it's definitely not actual malice. And Jamie, that's like even more boring documents than this. They can be fun to do, and you can learn a lot from them. It's, you know, I've mentioned before how I suffer from imposter syndrome. You know, I graduated law school with honors. I passed the bar with a very comfortable margin first try, but my brain shouts at me, you're not good enough, you're not good enough, you're not good enough. And you know, just reading documents like this, well, number one, reading like from Janet reminds me, hey, you know, there's a reason you graduated with honors from a very good law school and Janet didn't. But so a bit of an ego boost, but it also, you know, everything I read, I learn, whether it's what not to do, what to do. And so even for me, I learn a lot every document I read. It's, but some of them are not only educational, but as Emily D. Baker says, lawsuits are shade and allegation. At least the motions you write, shade and allegation. There's so much shade in this motion that it's fun. It's so much fun. So yeah, it's, you know, listening to DeCastro's drivel, delete laws. Oh, he's bad. And his lawyer that he's finally hired, Mr. Me, not much better. Craig Anderson, Vegas's attorney, he's decent. There's some quibbles, but he's decent. He's gonna win. But boy, this one is fun. So moving on. Courts in this district, however, have looked for something more than conclusory statements in order to infer the defendant knew the statements were untrue or recklessly disregarding the truth or falsity of those statements. Now, that's, you know, that's quoting from either Haywood versus Lucent or Ludlow versus Northwestern University. But either way, what does that remind you of? Oh, right. That reminds us of Twombly and Iqbal. You need more than conclusory statements. So it's not enough for Janet to say, hey, these statements by Caffinated Kitti were untrue, and she knew they were untrue. You need more than conclusory statements to show that Caffinated Kitti knew that they were untrue. Clearly, she didn't know that they were untrue. So, Pat's Cats, thanks for re-upping for another month. I really do appreciate it. And I appreciate all the rest of you being here too. Here, the complaint contains nothing more than the conclusory statement that KC's defamatory statements were made with knowledge of their falsity and with a reckless disregard for the truth. Basically, that's not even just a conclusory statement. That's just a recitation of the element of the cause of action itself. And what does Iqbal say? It says mere recitations of the elements of the cause of action are not enough. You have to allege actual non-conclusory facts. So they're nothing more than conclusory statements that Kitti's defamatory statements were made with knowledge of their falsity and with a reckless disregard for the truth. There are no facts alleged to support this boilerplate allegation. Boilerplate being it's just a recitation of an element of the cause of action. And without such facts, Braun cannot overcome application of the qualified privilege. Because Janet's claims for defamation against Kitti are legally deficient, Braun cannot satisfy her burden under the Georgia anti-SLAPP statute and demonstrating a probability of prevailing on the claim. I mean, DeCastro, as we know, is Captain Conclusory. I haven't decided on Janet yet. Like, I think she's probably a master of the conclusory arts, but since I haven't actually read any of her legal, like, pleadings, only her very bad cease and desist letters, which, you know, conclusory statements, who cares? They're cease and desist. But her attorney is very good at conclusory statements, but I don't know yet if they belong on the conclusory ranks. And we've discussed it before, Teragi. You might not have been here for it, but you know, I like alliteration, which is why I've used Captain Conclusory. There was a suggestion that Ashley Giard could be Corporal Conclusory. There's been Colonel Conclusory as a suggestion. What was the naval one? What was it? There could be Commandant Conclusory. That wouldn't be it, but either way, moving on. That's it. Commodore Conclusory. Thank you, J-Ben. That's the one I was trying to think of. Commodore Conclusory. Propson cannot prevail on her defamation claim. And yeah, Commander Conclusory as well. Commodore is the one I was trying to think of. The complaint alleges that Casey defamed Propson by publicly stating in the TikTok post that Propson was a TERF and transphobic, and used her platform to attack Propson's character and reputation. It depends, though, Pat's Cats. Are we in the Army, in which case captain would be above lieutenant, or are we... Well, no, captain is above lieutenant in both, I think. Either way. I've never been in the military, so I can make up my own ranks. It's my own damn armed services of conclusories. So the complaint alleges that the false statements were defamation per se because the harm to plaintiff's reputation is obvious and apparent on its face. Being called transphobic is akin to being called a bigot or a racist. Because the complaint alleges that Propson is a citizen and resident of Wisconsin, Wisconsin law governs the substantive issues of Propson's claims. See Townsend and Camelgard and footnote 6. And footnote 6 says, in the event that the court finds that Illinois law governs a determination of the legal sufficiency of Propson's claims, Caffinated Kitti has cited applicable Illinois law in connection with the analysis of Braun's claims. So basically, they're saying, hey, if you don't agree with us that Wisconsin law applies, even though Florida law probably should apply, you already have our analysis of Illinois law. And Jamie, enjoy your concert. I'm a little bit jealous, but I don't know. My musical taste probably differs from yours, so I might not be jealous, but I mean, you can see part of my musical taste wearing my Beatles shirt. I'd be really jealous if you were seeing the Beatles, but enjoy. Yeah. So, as explained above in connection with Braun's defamation claim, allegations that Casey defamed Propson by using her platform to attack Propson's character and reputation fail because Propson has failed to identify any particular statement that forms the basis for this allegation. If it's a dad band, I might like it. But dad bands could be 80s and 90s too, which, as I'm on the record, Sublime is the best band since the end of Zeppelin and Floyd. So, you know, I am a 90s kid. But yeah, so in addition to this, I don't know if they're going to mention it, but you know, there have been court cases where calling someone a racist is not defamation. So is like, even if she's not a TERF, and even if Caffinated Kitti stated as a fact that she is a TERF, is she technically committing defamation? I don't know. Probably not. But either way, this imprecision leaves Caffinated Kitti and the courts guessing as to which statements are at issue, and accordingly fail to plead facts to support the claim with adequate specificity. That's Westbrook versus Ulrich, Western District of Wisconsin, 2015, which dismissed a defamation claim because the allegations are too vague and conclusory as to the actual content of the alleged defamatory statements to satisfy Federal Rule of Civil Procedure 8. And remember, that was, we looked at the very beginning of this video at Rule 8A2, because the pleading standards for a complaint, you need a short and plain statement of jurisdiction, 8A1, a short and plain statement of the facts giving you the right to this cause of action, 8B2, and your prayer for relief, 8B3. So, yeah. That's it, Teragi. So, not a huge fan of Def Leppard. I'll listen to them. Zeppelin and Floyd, I consider sort of 1A, 1B. Almost tied, but not quite. And then it's, you know, sort of no particular order. The Beatles, The Doors, Sublime, Cream, maybe one or two others in that tier. And then the next tier is like The Who and Jethro Tull and Rolling Stones, those types of bands. But the thing about Def Leppard, though, is there are songs that I consider to be perfect songs. Like, they are so good, and that they don't even have to be complex. They just have to be so musically compelling that to me, they're perfect. And they're rare. So like Led Zeppelin, I consider like Since I've Been Loving You and In the Light and a couple others are perfect. Def Leppard, which song is it? It was it's not I can't think what it is. But they have one. They do have one. And it's yeah, my dad saw Zeppelin. He was supposed to see them twice, but the 1969-70 concert in a small venue that he had a ticket, but he was underage and they had just moved. And so my oma made him stay home and unpack. I think that's unforgivable, but either way. That's it, Linux guy. That I think S tier. That's probably what the perfect songs would qualify as, and just can't think which Def Leppard song it was. And like I said, it doesn't even have to be an overly complex song. Like the band Great White, their song Rock Me, I think, it is a pretty simple song, but it's just so compelling to me that I consider it a perfect song from an otherwise decent band. But yeah. But enough about music. Jamie's not even here and he's still distracting us. So then next citation, Patterson versus WWE, Eastern District of Wisconsin, 2005, where a complaint alleging defamation must set forth the particular words complained of. Here, Janet and Lauren didn't. They just said, well, yeah, they defamed me by, saying I'm a rogue attorney. But you didn't allege the actual words she used, because that doesn't help you, because the actual words, the particular words complained of, show that Kitti wasn't claiming it as a fact. It's couched in, if you are not this, then. It's not because you are this, then. It's a big difference. So as for the allegations that Casey stated Propson was a TERF, which the complaint alleges stands for trans exclusionary radical feminist, defined as someone who is hostile to the inclusion of trans women in the feminist movement, that statement is pure opinion and non-actionable under both Wisconsin and Illinois law. See Wagner versus Allen Media Broadcasting, Wisconsin Court of Appeals 2024. Ooh, a brand new case. This attorney's on it, which is good because, lawyers are required to stay on top of changes made to case law. Unlike, say, Michael Mee, who, was trying to say, well, delete laws, he made allegations that would survive Conley versus Gibson. Who cares that Twombly and Iqbal are 15 and 17 years old, respectively? It's not my job to stay on top of civil procedure that was taught to me in law school because it's old enough and I'm a new enough attorney. It was taught to me in law school, but we'll just use Conley versus Gibson. That's good enough. Rant over. But, this attorney using brand new month-old case law good attorney. Good attorney. Don't be a Janet. Don't be a Lockyer. Don't be a Michael Me. So next up, generally speaking, defamation claims must be based on statements of fact rather than expressions of opinion. And this is important. That's generally speaking. Some people, like, it worries me a little bit listening to Cece Suarez, for example, where she, you know, I'm using protective language. I'm saying in my opinion before everything. But if you say in my opinion and then state something as an actual fact, you might not be protected, even if you're trying to couch it in protective language. You've got to still be a little more careful. But generally speaking, that is the law. And that's Westbrook, which says statements of opinion are not defamatory. A defamatory statement must, 1, assert or imply a fact that is capable of being proven false, or 2, it must assert an opinion that directly implies the assertion of an undisclosed defamatory fact. It is not possible to prove that Propson is not someone who is hostile to the inclusion of trans women in the feminist movement. Whether Propson is or is not hostile to trans women is entirely subjective and could vary from person to person. Statements of opinion are not actionable if they merely express a subjective view. See also Kaminsky versus Wisconsin Cent Limited, Eastern District of Wisconsin 2000, which held that subjective impression is not sufficiently factual to be susceptible of being proved true or false. And Colborn versus Netflix, Eastern District of Washington 2024, found the same. Further, as the Seventh Circuit has held, words that are merely name-calling or found to be rhetorical hyperbole or employed only in a loose figurative sense have been deemed non-actionable. That's Juan versus Denton, 7th Circuit 2016, applying Illinois law, and citing Milkovich, a Supreme Court case, which says statements that are not reasonably understood as stating actual facts should not be actionable in order to ensure that the public debate will not suffer for lack of imaginative expression or the rhetorical hyperbole which has traditionally added much to the discourse of our nation. So here, going back up a little bit, words that are mere name calling or found to be rhetorical hyperbole or employed only in a loose figurative sense have been deemed non-actionable. So that would be Lauren the Mortician is a TERF. That's name calling. Lauren the Mortician is racist. That would be name calling. I'm not asserting she's racist, but that's an example. That would be name calling. So, yeah. And that's, like I said, he's a California attorney. He's a very good attorney. He might be $1,000 an hour. I don't know. I'm just saying it's a possibility. He's very expensive. But if he's able to get this dismissed on the special motion to strike, the SLAPP motion, hey, I'd rather pay an attorney $1,000 an hour for 10 hours of work than, $500 an hour for 1,000 hours of work. Sometimes paying for the more expensive attorney is worth it. I've mentioned before, I worked for a criminal defense firm that was really the cheapest option. They weren't cheap, but they really were the firm that if you qualified for the public defender but wanted a private attorney, that was the firm you went to. And I've said I'll never do that again because, first of all, you're indicating your quality. And you know, charging top of the market, not necessarily good. I've always said, you know, I think charging 2/3 of top of the market, you know, 2/3 of the way between bottom and top of the market, probably the right place to be, because it's a signal that there's psychology that goes into pricing, and those are the clients I want. So, you know, I'd rather charge more than even I think I might be worth. And, you know, if they say, hey, I really like you, can you give me a discount? I'd rather charge more and give a discount than just be bottom shelf pricing to start with. So, as for the complaint's allegation that Kitti defamed Propson by stating she was transphobic, a transcript of the TikTok post reveals that Kitti never called Propson transphobic. Not once in the TikTok post does Kitti use the word transphobic, nor does she ever accuse Propson of disliking or being prejudiced against transgender individuals. Rather, the transcript from the TikTok post demonstrates that Kitti stated only that Propson was following and actively liking social media posts by individuals who posted incredibly transphobic and hateful rhetoric. Nowhere in the complaint does Propson allege that this statement is false, i.e., that she did not follow and actively like social media posts by these particular individuals. And the TikTok post reveals that Propson did actually like and follow these individuals. And we have footnote 7 from which is quoting Osundairo, court case that said, a court may consider transcript of the TikTok post in determining legal sufficiency of a defamation claim. So, and that's a good point, Teragi. It's you know, just like Ethan Klein, the H3H3, really set the bar, at least on YouTube, for copyright. You know, that's a pretty landmark case. For defamation on YouTube, we have the Cardi B lawsuit is a big one, but this really could be a pretty precedential case, because you know, the world of YouTube and commentary, and I say YouTube, but that includes TikTok and Facebook video and stuff. It's really is still the Wild West. It's not entirely settled, and so this could be big. I mentioned the Grant Cardone case. I still want to do that one. Based on Florida's law, I think it could end up in the Supreme Court, the Grant Cardone case. So it's fun. And Paul Berry, good to see you. He could be conclusory counsel. That's not a military rank, but I'm sure the conclusory armed forces would have JAG attorneys. So that's it. It's you hurt my feelings, therefore I sue. It's like in first grade, we'd go around, you know, if I didn't like something, a classmate of mine said, I'm suing. And that's what this strikes as. It's you hurt my feelings, therefore I sue. but it doesn't work that way. Given that the statement that Propson follows and likes these social media posts is not false, it cannot form the basis for a defamation claim. That's Laughlin versus Bekah, Wisconsin Courts 2015, which says substantial truth is a defense to a defamation action. See also Harrison versus Chicago Sun-Times, Illinois Appeals Court 2003. And I don't know if I pronounced this citation right, but I think for this case it has to be Laughlin as opposed to like Laughlin or whatever, just because we're in Funnyville. It's Laughland. As explained above, because Propson does not identify any particular statements that forms the basis for her transphobic allegation, the defamation claim based on this allegation must be dismissed for lack of specificity. That's Westbrook, which dismissed a defamation claim because the allegations are too vague and conclusory as to the actual content of the alleged defamatory statements. See also Osundairo, which applied Illinois law to this analysis. Even if Propson had pled any facts supporting it, she hasn't pled any facts, but even if she had pled any facts supporting the allegation that Casey had accused Propson of being transphobic, which she did not, such a statement is not capable of being proven false and therefore is not actionable. CEG, Law Offices of David Frieden versus Chamara, which is from a state court, or 7th Circuit 2022, which says generally calling someone a chauvinist or racist is a non-actionable statement of opinion. And like I mentioned earlier, there are court cases that say calling someone a racist is not defamation. This is one such case. Law Offices of David Frieden versus Chamara. Generally, calling someone a chauvinist or a racist is non-actionable. Now, calling someone a TERF sounds an awful lot like calling someone a chauvinist. So, and Pat's Cats, that's the YouTube standard. Ask Jamie Grayson what it is on TikTok, because his entire TikTok channel got deleted. At least his main one. Caffinated Kitti, I believe, that this got her Facebook deleted and it was monetized. I may be getting those two mixed up, but these false strikes, they have real world consequences. And like I said earlier, he's at a concert now, so he can no longer confirm it tonight, but he's said he's tight-lipped, but he's exploring it, so don't be surprised if we get another lawsuit to cover, with only that one would be with Jamie as the plaintiff. And that would be more fun. So, next case, La Liberty versus Reed, 2nd Circuit 2020. Accusations of concrete wrongful conduct are actionable, while general statements charging a person with being racist, unfair, or unjust are not. So, TERF, unscrupulous, files false copyright strikes, rogue attorney, unfair, unjust, sounds awfully similar. Terry versus Journal Broadcast Corporation, Wisconsin Court of Appeals 2013. Use of terms rob and cheat were non-actionable opinions under Wisconsin law. And Huon, mere name calling is not actionable as defamation under Illinois law. And And that's it, Pat's Cats. I don't know if TikTok it's once, twice, if it's once with an attorney. That's the problem with face or with YouTube. You at least know it's 3 strikes, but you look, and Delete Laws has done hundreds of strikes against some content creators, and Facebook's like, yeah, these are all false strikes, so we're not going to count them. But it's bad. And Giard, her main TikTok was deleted, I think, but she's still on there. She has a YouTube channel, not a lot of content on it, but it's bad. She's awful. So, but I don't know that Giard has copyright strikes. Hers are defamation. So, moreover, Propson's defamation per se claim against Casey should be dismissed because accusing someone of being a TERF or transphobic is not one of the specific categories of statements that fall within the definition of defamation per se under either Wisconsin or Illinois law. See Kennedy versus Children's Services, Society of Wisconsin, 7th Circuit, 1994, which held that statements must fall within 4 specific categories to be considered slander per se under Wisconsin law. Imputation of certain crimes, so like murder, theft, whatever, crimes of moral turpitude generally. Allegations affecting one's business, trade, profession, or office. Lauren being a TERF, allegedly. Does that affect her business as a mortician? Probably not. As a TikToker, hey, according to, conservative Vance audience, it might boost her profile. Imputation of a loathsome disease. Being a TERF isn't an STD, so that probably doesn't count. Or imputation of unchastity to a woman. Well, being a TERF isn't synonymous with being a whore either. So, see also Green from an Illinois court, which sets forth categories of defamation per se under Illinois law. Thus, Propson must plead specific allegations of special damages resulting from the defamation, which the complaint fails to do. So they're missing an entire element. Damages. Remember, I hate to keep going back to it, but remember in Depp versus Heard, we had days of testimony of what damages they both suffered. Talking about, is Amber Heard on the level of this actress or this actress and how much she should have earned? And, is Johnny Depp, he missed out on Pirates of the Caribbean 6, which would have made him this much money, and, on and on and on. So, yeah. And that's the thing, Pat's Cat. It's, you listen to Bunny XO and Lauren the Mortician when Lauren went on Bunny XO's podcast, and they basically said, yeah, we have our attorney, Janet, go after people and file copyright strikes if I don't like what they said. That's not a copyright violation. It's, it's not very good. So thus, Propson must plead specific allegations of special damages resulting from the defamation, which the complaint fails to do so. See Kennedy versus Children's Services, Society of Wisconsin, 7th Circuit, 1994, which dismissed a claim for defamation for failure to state a claim when special damages were not pled. General allegations of harm to Propson's career, profession, and reputation, or allegations of emotional distress are insufficient to adequately plead special damages. See Rivera versus Allstate Insurance Company, Illinois Appeals Court 2021, applying Illinois law. Likewise, a conclusory allegation that Propson lost a contract with a famous documentary channel without any supporting facts explaining that she lost the contract because of the alleged defamation is insufficient to plead special damages. That's Quinn versus Jewel Food Stores, Illinois Appeals Court, 1995, applying Illinois law and holding that plaintiff failed to plead special damages to state a claim for defamation because plaintiff provided no explanation that denial of a franchise was because of defendant's statements. So here, Lauren would have had to say, I was about to sign a contract with Netflix, Discovery, whatever, for a documentary channel. I was to be paid this much money. I lost that contract because of Caffinated Kitti's statements. Netflix or Discovery or whoever sent me this, rescission of contract letter stating, because of these statements made, we are no longer going to do business with you. But there's none of that. It's just, yeah, I was going to do a documentary with a famous documentary company. It's unnamed, but I was going to do it. It really existed. They really wanted me. And then they didn't want me all of a sudden because of that dirty Caffinated Kitti. You know what that sounds like to me? That sounds to me like very unspecific conclusory allegations. Linux guy, it's only $402 in federal court to file that lawsuit to ruin your life. So, but that's why we have these fee shifting statutes like the SLAPP statutes, where if you bring a frivolous suit like this, you can get your lawyer's fees covered. But the problem with that is, look at Delete Laws. You'll never get a penny from him. You can't get blood from a turnip. But from Lauren and Janet, you might. You might at least get some of it. And luckily, with GoFundMe, it's been a while since I've looked, but the Girlies raised a lot of money. I told them it wasn't going to be enough because lawyers are expensive. You look, Kate Masshole raised 60 grand in very short time. She's got a relatively small channel, a lot bigger than mine, but Atozy almost overnight raised 240 grand, and that got BitBoy Crypto to dismiss his claim because he's like, well, I thought you weren't going to be able to defend yourself, but now that you made it public and you have all this money to hire a lawyer, that's not what I wanted, so case dismissed. But that luckily in this day and age there are ways to not have your life ruined by it, or at least not completely, but it's still awful. But then you look at it, Ashley Giard, for even less than $402, you can ruin someone's life by making completely frivolous claims about them, calling them a murderer on 100+ TikToks. And Professor Schofield, her GoFundMe is still alive. She still has lots of legal bills trying to prove, hey, I'm not a murderer, and this moron, unscrupulous charlatan TikTok psychic made stuff up about me. So, and that's it, Linux guy. Until a conclusion has been made that someone is a vexatious litigant, it's, they're given benefit of the doubt, at least that their claims aren't frivolous. And they can do a lot of damage before they're labeled vexatious, and that's not even in every court. It sucks, but you've also got to protect plaintiffs, because their life might have actually been ruined. So, and that's it. They can garnish. She's got a house in South Carolina. She's got a house in Illinois. One of those wouldn't be protected by a homestead exemption, presumably. So they could seize one of those houses. Lauren, she's presumably making decent money on TikTok. She's had brand sponsorships. She, presumably she's got assets to seize. So you can garnish wages, but if they've got assets to seize, you do that first. So let's see. We saw that the alleged contract with a famous documentary channel without supporting facts, not good enough. And that's citing Quinn versus Jewel Food Stores, Illinois Court of Appeals, 1995, applying Illinois law and holding that plaintiff failed to plead special damages to state a claim for defamation because plaintiff provided no explanation that denial of franchise was because of defendant's statements. All right, we already read that part, but tangents make me lose my place sometimes. So next up, plaintiffs cannot prevail on their false light and trade libel claims. Because plaintiffs have failed to state a claim for defamation against Caffinated Kitti, their respective false light claims against Caffinated Kitti, counts 5 and 6, arising out of the same allegations, fail as well. See Madison versus Frazier, 7th Circuit, 2008, which found when an unsuccessful defamation per se claim is the basis for a plaintiff's false light claim, his false light invasion of privacy claim fails as well. And Terry versus Journal Broadcast Corp., Wisconsin Court of Appeals, 2013, Wisconsin does not recognize a claim for false light. So Lauren is bringing claims that aren't even a recognized cause of action. She's trying to say, well, we're bringing the claims in Illinois, and Illinois has false light, but even though the damage was probably felt in Wisconsin, because that's where I am, and that's where claims against me would have been brought, so Wisconsin law applies to claims I bring, but Wisconsin doesn't have this cause of action. So let's just pretend that we can use Illinois law for the sake of me, Lauren the Mortician. So Atosi, I believe, lives in Utah's boots, meaning Arizona. He grew up in Norway. So likewise, because plaintiffs' trade libel claims against Caffinated Kitti are nothing more than a restatement of the defamation claims, and based on the same alleged false statements by Caffinated Kitti, the trade libel claims suffer from the same deficiencies as the defamation claims discussed in sections 8.3a and b above. Plaintiffs cannot prevail on their tortious interference claims. Propson's claims for tortious interference against Caffinated Kitti, count 13, asserts that Caffinated Kitti's alleged defamatory statements intentionally interfered with a contract Propson had with a famous and well-known documentary channel. Braun, Janet, has likewise asserted a claim for tortious interference with existing and potential business relationships against Caffinated Kitti, based on allegations that Kitti's purported defamatory statements have caused and are likely to cause the public and content creators not to employ Braun for legal representation. The thing is, it's Janet's own nonsensical cease and desist that is so laughable. Exposing that should be enough that content creators look at that and say, I don't want an attorney that does that. That's bad lawyering. Why would I hire that nincompoop? Both claims are legally deficient. As a preliminary matter, once again, that's polite legal speak for, first of all, as a preliminary matter, both claims for tortious interference are based on plaintiff's non-actionable allegations of defamation. And see also Leva versus City Finance Company, Wisconsin Court of Appeals, 1980, where a failed claim for defamation cannot subject one to liability for tortious interference with a contract. And even still, but I can't name Wisconsin's exact tortious interference, the exact elements of it. But even if this were actually defamation, which it's not, Lauren losing the purported documentary, that wouldn't be tortious interference, because tortious interference would require like Caffinated Kitti saying, hey, Netflix, I hear you're trying to get a contract with this bozo. She's a TERF. You should really reconsider your contract with her. That would be tortious interference. But doing something that has absolutely nothing to do with the contract, not directly interfering with it, that's generally not going to be enough for tortious interference. So, yeah. And that's it. False copyright strikes, even legitimate copyright strikes, could sink your channel, because it's one of the biggest faux pas you can make on YouTube, on TikTok. It's no one's going to want to deal with you. It's going to give you a bad reputation. Your audience is going to really not going to like it generally. So, Charlie, Moist Critical, he probably could copyright strike a dozen people a day with legitimate claims. But he doesn't, because he knows in the long run it only hurts him. So, furthermore, under Wisconsin law, which applies to Propson's claim, a claim for tortious interference with a contractual relationship requires the plaintiff to allege that the defendant acted with a purpose to interfere with the contract, which is basically what I just said. When I said I didn't know the exact language of Wisconsin's law, but just defaming someone isn't tortious interference of a contract. It requires that you act with the purpose of interfering. So, hey, Netflix, don't hire this nincompoop. She's a TERF. That would be tortious interference with a contract. Not a general statement that this person has liked posts by people who are transphobic and problematic. And that's it. If you're inept and you're trying to hide it, the worst thing you can do is bring attention to it. And bringing lawsuits against people with a gigantic platform, like, say, 1 million TikTok subscribers, 100,000 YouTube subscribers for Do We Know Them, Girlies? That's not a good way to keep something hush-hush, because they're going to shout it from the rooftops. And Linux Guy, thanks for joining as a member. I appreciate it. So that last bit was quoted from Fosside versus State Bank of Cross Plains, Wisconsin Court of Appeals, 1995. If an actor lacks the purpose to interfere, then his or her conduct does not subject him or her to liability, even if it has the unintended effect of deterring a third party from dealing with the plaintiff. So, if Caffinated Kitti didn't mean to interfere with the Netflix or whatever documentary, if she didn't even know of the documentary, she couldn't have interfered, and therefore, even if she unintentionally did cause the breakdown in that contractual relationship, it's not actionable. It's not actionable. It doesn't work. So necessarily, to be subject to liability for tortious interference with a contract, the actor must have knowledge of the contract with which he is interfering and the fact that he is interfering with the performance of the contract. That's from the Restatement, Second of Torts, Section 766, Comment I. The complaint alleges no facts establishing that Caffinated Kitti knew about Propson's alleged contract with the documentary channel and that she acted with the purpose of interfering with that contract. Rather, the complaint relies on nothing more than conclusory and insufficient allegations devoid of any facts. She doesn't even tell us what the contract was. So, and that's it. The Do We Know Them is 100,000 subs, but they're fairly dormant. But pre-existing individual channels are, what, 400,000 subs for Lily. I don't know how many Jesse had, but they've been around forever, and they have a lot of reach. They're, as they say, the reason they named their podcast Do We Know Them is because there's a good chance the people they're talking about, they know them. And yeah, Lauren hides her possible feelings about others. She wants no one to know. And Janet hides her lack of law prowess, I'll put it. So rather, the complaint relies on nothing more than conclusory and insufficient allegations devoid of any facts. I already read that, but that's Rauman Consulting versus Symbiont Construction, Eastern District of Wisconsin, 2019, which says vague and conclusory allegation is insufficient to state a plausible claim for tortious interference. And that sounds like, it's basically restating Twombly and Iqbal, but applying it specifically to tortious interference. This is very good lawyering. And that's it, Pat's Cats. If someone points out a fault you have, the solution isn't to silence them, it's to fix yourself. But you've got to have integrity. You've got to have the ability of introspection to fix yourself. And I don't think either of them do. Oop, didn't mean, thought I had already not already hit that. So, indeed, the complaint makes clear that Caffinated Kitti's motivation in making the statements about Propson on TikTok was to clear up confusion between Propson and Kitti, not to interfere with a contract between Propson and the documentary channel. Moreover, the complaint is devoid of any factual allegations establishing that Kitti's statements were the cause of the documentary channel's termination of its contract with Propson. That's Ducto Wire Company versus U.S. Crane Inc., 7th Circuit, 1994, which said, essential element of tortious interference claim is that a causal connection exists between the interference and damages. And our old friend Twombly, which says, complaint must allege enough facts to state a claim to relief that is plausible on its face. Like I said, I think they haven't even adequately pled that Lauren had a contract to begin with. Who was it with? What was it for? What was she making? These are threadbare allegations. So, and that could be it. They thought this would be an easy, force them into settlement, and I mentioned a Tozy when he was sued by BitBoy, and BitBoy was real salty when he made his video saying he dropped the case because the Tozy raised attorney fees real fast, and he was like, last time I did this, it wasn't made a big deal, it wasn't public, and I thought we'd settle it behind the scenes like men. And it's like, so you thought you could bully him into a settlement and he wouldn't expose you as a bully? And Lauren and Janet apparently didn't realize that if you've got a public platform, you're going to use it to expose your bullies. And the Tozy lawsuit was like 2 or 3 years ago. So it was before they took my Lambo. So, yeah. But yeah, BitBoy was nuts. It would appear. So, Braun's tortious interference claim is equally deficient. Under Illinois law, which applies to Braun's claim, a claim for tortious interference with prospective economic advantage requires that plaintiffs, 1, show their reasonable expectation of entering into a valid business relationship, 2, defendant's knowledge of that expectancy, 3, purposeful interference by the defendants, preventing that expectancy from being fulfilled, and 4, damages resulting from such interference. See Hackman versus Dickerson Realtors, Northern District of Illinois, 2008. So basically it's saying, hey, you've got to show the reasonable expectation of entering into a business relationship, defendant's knowledge of that expectancy. So it's like, well, yeah, you're a lawyer. We know that you're always trying to hire new clients, but show us the client that we interfered with. Show us the client that we knew you were forming a contract with. We interfered with the formation of that contract. You were damaged by it. Here, the only contractual relationship we see that is even relevant here is her contractual relationship with Lauren the Mortician. And here, she did nothing to interfere with that. She just said, hey, if she hasn't retained you, you're going to cause her trouble. In fact, as far as we know, Lauren is still her client. Not in this lawsuit, because that would be even more unethical than I believe she's being by being co-plaintiffs with her. But what? Show us the damages. Show us the contract that was interfered with. You haven't. You've just said, oh yeah, she interfered with my contract. Give me money. It doesn't work that way. Braun, Janet, fails to allege any specific facts regarding the existing or prospective relationships with which Caffinated Kitti allegedly interfered. Rather, the complaint alleges only conclusory allegations that Kitti has caused the public and content creators not to employ Braun. Per the complaint, the interference claim could be based on any member of the public. There was no specific relationship identified and no facts alleging that Kitti knew of these potential or existing relationship. Such conclusory allegations are too vague to state a viable claim for tortious interference under Illinois law. And that's, once again, Hackman, which dismissed tortious interference claim that alleged defendant's conduct caused unidentified agents to quit Hackman's employ. So, no. If Jamie sued and won, TikTok wouldn't have to reinstate his channel. He'd have to probably sue TikTok to say, hey, you didn't follow your terms of service, let me back on. And that's, they'll say, yeah, well, they're our terms of service, not a law. We didn't want you on here anymore. But, if he were to sue, like, I think he's got several valid causes of action, but the defendant of a false copyright strike can bring the copyright suit as a plaintiff to assert fair use. So when you receive a copyright takedown on YouTube, YouTube says, hey, we'll go through the claim and notice and counter notice, and we'll use our best judgment whether or not we keep the video up in the meantime. But if the allegedly infringing party does a counter notification, you've got so much time as the plaintiff to show us, hey, we have sued, but or that there is litigation. So Jamie could bring the copyright suit himself to assert his copyright rights, to say, hey, this was fair use. They have damaged me. And if he wins that, he theoretically could go to TikTok and say, hey, I won the copyright suit. TikTok would not be obliged to let him back on, but I bet they would back on. And that's it. Jamie absolutely has lost out on income, but so has Kitti by losing her monetized Facebook account, if I'm remembering correctly. So they've all suffered damages from Janet and Lauren's shenanigans. So, moreover, Braun has alleged no facts to support any allegation that members of the public have failed to employ Braun for legal representation as a result of Casey's statements. Instead, the complaint relies on a conclusory assertion that Kitti's statements have caused or are likely to continue to cause people not to hire Janet. That simply is not enough to state a claim for tortious interference. And that's, once again, the Hackman case, which dismissed a claim for tortious interference based on generic allegations that fall short of establishing the causation required for a claim for tortious interference with an existing business relationship and are too attenuated and speculative and vague to state a plausible entitlement to relief. And that case was citing Twombly once again. So, like Janet just saying, well, yeah, this defamation made the public stop hiring me, but that's not even reciting Like, remember, Iqbal says bare recitals of the elements of a cause of action do not suffice. That's not even a bare recital of the elements of a cause of action. That's just saying, hey, she caused people to stop hiring me. She hasn't shown anyone that, that was going to hire me and didn't. I haven't shown any of the elements, but I haven't even stated the elements. But give me money. That's nonsense. And that's a good question, Linux guy. Who are the little people? Who are the people who didn't have a large platform like Caffinated Kitti and Bekah Day and Do We Know Them? If she came after me, of course, I could sue her myself. I don't have a massive platform. Could she get me shut down? I'd prefer not to find out, but I'd make it expensive for her if she did. Propson cannot prevail on her intentional infliction of emotional distress claim. Now, remember, I've said civil conspiracy, RICO, it's never RICO. RICO is the legal equivalent of lupus. Intentional infliction of emotional distress is lupus light. It's RICO light. It requires outrageous conduct. We're talking, a drunk driver runs down a kid in front of his mother. That would probably be negligent infliction of emotional distress. But that gives you the level, if it's not done in front of the mother, if the mother's in watching her soap operas and doesn't see it, she's got, major emotional distress, but it doesn't work. It's not enough. So, but we'll see what this lawyer has to say about it. Propson's claim for IIED against Caffinated Kitti is based entirely on Kitti's alleged defamatory statements. Because Propson has failed to state a claim for defamation, she has also failed to state a claim for emotional distress. That's Terry versus Journal Broadcast Corporation, Wisconsin Court of Appeals 2013, which affirmed dismissal of emotional distress claim that was derivative of failed defamation claims. See also Huon versus Breaking Media, Northern District of Illinois, 2014, affirmed in part, reversed in part. Huon versus Denton, 7th Circuit, 2016, dismissing emotional distress claims based on failed defamation claim, since statements that do not rise to the level of defamation logically cannot rise to the even higher level of extreme and outrageous conduct. Because there is no probability that Braun and Propson will prevail on the claims they have asserted against Kitti, the second prong of the Georgia anti-SLAPP statute has been satisfied. The claims asserted against Kitti should be stricken, and Kitti entitled to an award of her attorney's fees. Alternatively, so 25 pages in, we are finally to the pleading in the alternative part. So it's, if you don't see fit to grant the special motion to strike, the SLAPP motion, you should at least dismiss based on failure to state a claim upon which relief can be granted. And we've already seen most of the argument for this 12b6. So, as explained in the sections above, plaintiffs are not likely to prevail on any of their nine causes of action asserted against Kitti because they are legally deficient, i.e., they fail to state a claim under Federal Rule of Civil Procedure 12b6. In the event that the court determines that Kitti's conduct is not a protected activity and does not satisfy the first prong of the Georgia anti-SLAPP statute, Kitti respectfully requests that the court alternatively dismiss the claims under Federal Rule of Civil Procedure 12b-6. Alternatively, Propson's claims should be dismissed under Federal Rule of Civil Procedure 12b-3, as her claims have zero nexus to Illinois. A civil action is properly venued in 1. A judicial district in which any defendant resides, if all defendants reside in the state housing the district. So, Georgia, for example, might be a proper venue. 2. A judicial district in which a substantial part of the events or omissions giving rise to the claim occurred. Well, Kitti made all the statements in Georgia. She published them in Georgia. Her TikToks were made in Georgia. None of them, as far as I know, in Illinois. So prong 2 is a no. Or 3, if there is no such district in which the action may otherwise be brought, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to the action. See 28 U.S.C. section 1391b. That's the venue statute. See also Clark versus McDonald's Court, Southern District of Illinois, 2023. As explained above, 2 different plaintiffs have brought 9 causes of action against Kitti, 5 by Propson and 4 by Jeanette, and venue must be proper as to each cause of action. Scotch Whiskey Association versus Majestic Drilling Company, Northern District of Illinois, 1988. That's it. They want to silence their critics, and that's exactly the conduct that a SLAPP law contemplates. That's what SLAPP laws exist for, is so that you can't silence your critics. It's the short circuit mechanism. It's, you're not going to win this defamation case, so let's get rid of it right out the gate. So Federal Rule of Civil Procedure 12b-3 allows a defendant to make a pre-answer motion to dismiss on the grounds of improper venue. And remember, we've looked at Rule 12b in general and 12b-3, but to bring those 12b motions, you can bring them before a responsive pleading. So you bring them before an answer. So the pre-answer motion to dismiss. Similarly, 28 U.S.C. section 1406A allows a court to dismiss a case when venue is improper. See 28 U.S.C. section 1406A, which provides that the district court of a district in which it is filed a case laying out venue in the wrong division or district shall dismiss. In fact, district courts often dismiss a case rather than transfer it under section 1406A if the plaintiff's attorney reasonably could have foreseen that the forum in which the suit was filed was improper and that similar conduct should be discouraged. 14D Federal Practice and Procedure, blah, 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 basically scholarly article type thing. Here, venue is improper with respect to Propson's claims against Kitti because Propson is a resident of Wisconsin. Kitti is a resident of Georgia, and none of the claims asserted by Propson against Kitti have any connection to the state of Illinois, i.e., no statements made in Illinois or directed at Illinois, no injury in Illinois. Indeed, as explained above, Illinois law does not apply to any of the claims asserted by Propson against Kitti. Propson should have filed this action in Wisconsin or Georgia, but she instead chose to tie her claims to those asserted by Braun for her own convenience. That is not a reason for this court to decide this issue, and dismissal of Propson's claims is warranted under Rule 12b-3. Conclusion. For the foregoing reasons, Kitti respectfully requests that this court 1. Strike counts 1, 2, 5, 6, 9, 10, 13, 14, and 15 asserted by Propson and or Braun against Kitti under the anti-SLAPP provision, and award Kitti the attorney fees she has incurred in connection with this motion under the anti-SLAPP law, or alternatively, dismiss all of the counts asserted by Propson and or Braun against Kitti for failure to state a claim under Rule 12b-6, or alternatively, dismiss the counts asserted by Propson against Kitti for improper venue under Rule 12b-2. Dated Leap Day 2024, respectfully submitted, Brandon J. Woodcow, attorney for defendants, Pro Hoc Vice, from Ventura Boulevard, Woodland Hills, California. Very good attorney, Mr. Woodcow. That was excellent. If a bit long, but a lot of that is my tangents. But yeah, I mean, Google, like I said, they do employ hundreds. They might employ 1,000 lawyers, and that's just their employed lawyers. They use Wilson Sonsini, one of the largest, most prestigious, best law firms. Like I said, Wilson Sonsini only recently opened an office here in Salt Lake City. The person from my law school class that they hired was already a partner at the best local Salt Lake City firm. He went from being a partner at the best local firm to being an associate. So he took a downgrade in title to join Wilson Sonsini. He probably got a big pay boost too, though. They also hired Christine Durham, the former Chief Justice of the Utah Supreme Court. That's the type of attorney Wilson Sonsini hires. That's the type of attorney Google uses in court. But Janet thinks she is able to dictate to Google how things are going to go. So, with that all being said, I had hoped to get through more than just this one, but, that was my hope. My realistic expectations were getting through just this one, but it was an extra long motion. Bekah Days is 18 pages and 18 for Do We Know Them? So the other girlies combined are about the same as Caffinated Kitties. So that being said, I think that's where we're going to end it for today, since we're going on almost 4 hours and 20 minutes and I haven't had dinner yet. And I'm kind of tired because, live streaming isn't, despite some of the drama going on. I'm looking at you, Hassan, and already making fun of it. Live streaming, reacting to videos, fine. But where you've got to be on the whole time, it is exhausting. So 4 hours is exhausting. But yeah, so I'm hoping, I know I've said it the last several videos, I'm hoping not to leave it another week this time, because I really want to, especially with how good this one has been, I really want to get the rest of this one done. I really want to get caught up on delete laws. I really want to do the complaint in Cardone versus Leger. I really want to do that. other one that I've been promising for like a month that's already ended. So hopefully I'll get those to you sooner. But either way, thank you for joining me. Like, share, subscribe. I still need to do LVMPD's reply brief. That's what I have on delete laws. But I think for most of this, I've just had myself on Twitch. But if you happen to have watched this on Twitch or find yourself watching this on Twitch, please subscribe to my YouTube. Keep watching on Twitch, but whatever. If you're on YouTube watching this and you do have Twitch, go follow me on Twitch. Help me get into the algorithm. I figure, if I can have a few more people watch on some other platform, I may as well. So with all that said, like, share, subscribe. I will see you soon. Bye-bye.